Hey, I'm on TV.
Aloha, my kako. In a number of years, I had that gavel in my hand. This is the April 14th, 2022 Land Use Commission meeting. This is our first hybrid meeting, which is being held in a physical meeting location open to the public here at Honolulu International Airport, and also by interactive conference technology, which links video conference. I cannot put people on mute next to me. Which links video conference participants and other interested individuals of the public via the Zoom webinar platform in order to comply with state law. Members of the public are able to attend this in person or view the meeting via the Zoom webinar platform. For all meeting participants, I'd like to still emphasize the importance of speaking slowly and clearly. And if you have one here directly into your microphone, we do the recordings of this meeting from the Zoom, or we do the transcripts of this meeting from the Zoom recording, so it's very important to have a clear audiovisual signal. If you are tuned into this, your participation in the Zoom meeting is your implied consent to be part of the recording of this meeting. If you do not wish to be part of the recording, you should exit the meeting now. This meeting allows the conference, this Zoom conferencing technology allows the meeting participants and other participating members access to this meeting via their own digital devices and internet access for reasons that are beyond many of our individual control. Occasional disruptions to connectivity may occur from time to time. If this happens, please let us know. And that's going to be especially important during this hybrid work, because we're going to be trying to pay attention to people physically with us as well as virtually. So let us know if you're having problems accessing the meeting, and please be patient with us as we try to restore audiovisual signals. Public testimony during this meeting, the only item which is open for public oral testimony is the adoption of the minutes. We closed public testimony on the main docket item at the last hearing on this matter. So we have received some written testimony. If anybody wishes to testify during the public testimony that's available on adoption of the minutes, if you are calling in by phone, press *9 to raise your hand virtually. If you are here in the room, there is a sign-up sheet in the front of it. We will take breaks from time to time, approximately 10 minutes every hour. In addition, due to schedule constraints from Commissioner Okuda, we will be taking a break at one point so that he can attend a court hearing. Commissioner Okuda, that will be at approximately what time do you believe?
Mr. Chair, that will be 5 minutes to 10 o'clock, probably for about half an hour, depending on when the court calls our case. Thank you.
Thank you, Commissioner. So my name is Jonathan Lee K. Schroyer. I have the pleasure of serving and the honor of serving as the Land Use Commission Chair. We currently have 8 seated commissioners of a possible 9. But we did actually get 4 more commissioners, replacing vacancies as well as existing commissioners who are attending this meeting, as I understand, virtually. Commissioner to-be Mike Yamane from Kauai is attending, I believe. Here in the room, I have Commissioner Don Chang from Oahu, Commissioner Nancy Cabral, who represents Hawaii Island, Leo Higashi from Maui, Commissioner Arnold Wong from Oahu. Virtually, we have Commissioner Dan Giovanni from Kauai and Commissioner Gary Okuda, who I mentioned already, from the island of Oahu as well. With us in the room, we have our small but mighty staff, our Land Use Executive Officer, Daniel Orendaker, our Chief Planner, Scott Derrickson, our staff planners, Wiley Hakoda, our Chief Clerk, Natasha Quinones, our Deputy Attorney General is tuning in virtually, Dan Morris, and we're all on a wall. As I said, court transcriptions are being done from the Zoom recording. Commissioner Axon is excused from today's meeting, and Commissioner Okuda will take the break as previously noted. For the commissioners who are participating in this meeting via Zoom, I'd like you to confirm whether you are alone in your room or if there's any other people present, and if so, who's present. Commissioner Okuda.
Mr. Chair, I am in the public area of the First Circuit courtroom. There is no one else, however, observing or participating with me, but it is a public area. Thank you.
Thank you, Commissioner. Commissioner Giovanni.
Similarly, Chair, I am sitting in a public area, in a lobby area of a hotel, Hilton Hotel in San Diego, but there's no other person within earshot or participating directly in this hearing.
Thank you very much. Are there any members of the public, sorry, our first order of business, having made it through that, is adoption of the March 23rd, 2022 minutes. Ms. Quinones, has there been any written testimony submitted on adoption of the minutes?
No, Chair, no written testimony has been received.
Okay, no written testimony. Are there any members of the public who are tuning in virtually who wish to testify on adoption of the minutes? If you're calling in, press *9. If you're accessing this via the Zoom webinar platform, please use the raise your hand function. Are there any men, seeing none, are there any members of the public who are attending physically who wish to testify? Seeing none. Commissioners, are there any comments or questions on the adoption of the minutes? Commissioner Cabral.
I move for the adoption of the minutes of the March 23rd, 2022 meeting.
Is there a second?
Chair,
Commissioner Wong.
this is Commissioner Wong, I second.
A motion has been made by Commissioner Cabral and seconded by Commissioner Wong to adopt the minutes. Is there any discussion? Seeing none, Mr. Ordenko, would you please poll the commission?
Thank you, Mr. Chair. Motion is to adopt the minutes. Commissioner Cabral,
Yes.
Commissioner Wong,
Yes.
Commissioner Axon is excused. Commissioner Chang,
Aye.
Commissioner Okuda,
Yes.
Commissioner Giovanni,
Aye.
Commissioner Ohigashi,
Yes.
Chair Schreier.
Aye.
Thank you, Mr. Chair. The motion passes unanimously.
Thank you. Mr. Ordenko, would you now please go over our next meeting agenda item, the tentative meeting schedule?
Thank you, Mr. Chair. Our next meeting will be on April 27th in Hilo for the Church Hildau motion for reconsideration. We'll also begin discussion on the election of officers for the upcoming year and staff performance reviews. We will be on Kauai on May 11th for a continuation of the Keikaha Ag matter. We will also be on Kauai on May 12th, where we will be honored by Chair Schreier's presentation on the public trust doctrine. On May 25th, we will be on Oahu, if necessary, for this continuation of this matter. And if we conclude today, that will be the adoption of the order. June currently is open. However, we are anticipating those dates to be filled in the near future. So we would ask that the commissioners keep those dates open. July, we have the 13th and 14th scheduled for tentative meetings, although the dockets have not been determined as yet. On July 27th and 28th, we are anticipating a training session for the new commissioners. And that's all we have on the calendar so far.
Thank you, Mr. Ordenker. Commissioners, are there any questions for Dan about our meeting schedule? Dan or Gary? None. Our next agenda item is a continued action for docket number A87-610, Kamehameha Schools, Waiawa, Oahu, to consider the petitioner's motion for modification, time extension, the release and modification of conditions of an order granting a motion for an order amending the findings of fact, conclusions of law, and decision and order issued by the commission on February 11th, 2020, to allow for modification of phase 1 and phase 2 of the solar farm and to modify and release various conditions under the Commission's 2014 and 2020 decisions and orders concerning requirements of the submission of a master plan, archaeological sites and plans, burial plans, historic resources, aircraft hazards, traffic, development plans and schedules, and decommissioning of the solar farm phases. Will the parties please identify yourselves for the record, starting with the petitioner?
Good morning, Chair and Commissioners. Am I loud enough?
Maybe a little louder would be good.
Start again. Good morning, Chair, Commissioners, other parties. Jennifer Lim, representing petitioner Kamehameha Schools.
Morning, Chair and Commissioners, Onalda Film, co-counsel for petitioner Kamehameha Schools. With me today is Derek Simon. Thank you.
So you press the button until it's lit, and then you don't have to hold it down, it should stay lit, and speak directly into the microphone.
Good morning, Deputy Corporation Counsel Brianna Weaver, appearing on behalf of the Department of Planning and Permitting.
I'm going to say, I am in the same room and having a hard time hearing.
Should the light be green or is it supposed to be
It should
red?
be orange. Did you press the bottom button?
Yes.
Okay.
Be louder.
Among the artifacts that I'll just note for everybody that we're having is that we actually have a number of participants who've only participated virtually in our meetings, who've never actually participated physically. So there's going to be that aspect of things going on as well.
Good morning, Deputy
Much better.
Corporation
Welcome.
Counsel
Aloha.
Brianna Weaver, appearing on behalf of the Department of Planning and Permitting. With me are Franz Cranes and Dina Wong. Thank you.
Thank you. Office of Planning and Sustainable Development.
Good morning, Deputy Attorney General Brian Yee, on behalf of the Office of Planning and Sustainable Development. With me is Lorene Maki and Rodney Funakoshi from the Office of Planning and Sustainable Development.
Thank you. I will note that I think it will work better for our hybrid meetings in the future if we all have access to laptops with screens so that we can see your beautiful smiling face. Let me now update the record. On April 4th, 2022, the LEC mailed and emailed the meeting agenda for this meeting to the parties in this docket to our statewide and county mailing lists. On April 7th, the petitioner filed its second list of witnesses, second list of exhibits, a certificate of service, and exhibits 42 through 47. On April 12th, the Department of Planning and Permitting filed its notice of appearance of counsel of Brianna Weaver. Also on that date, the commission received additional public testimony. Let me go over our procedures for today. First, I will ask the commissioners if there's any additional disclosures to make. Next, I will recognize any written public testimony. As I mentioned before, I did close oral testimony on this matter at the last hearing. So there will be no further oral testimony on this matter at the time. After the notification of written testimony, the petitioner will continue their presentation from where they left off. Before that, we will accept new exhibits into the record as proposed, or consider the acceptance of new exhibits into the record as proposed by the petitioner. Then we will hear from the petitioner continuing their presentation, followed by the DPP and then OPSD to make their presentations with questions and comments from the commissioners. The petitioner will be given the opportunity to provide any rebuttal, and after all parties have presented their arguments, presuming we make it through all of that, the commission will conduct formal deliberations and issue a decision on the motion. As noted, from time to time, we will be taking breaks, one at approximately, I believe, 5 minutes to 10. We will lose one of our commissioners at 3 p.m. So the goal is to hopefully make it through our proceedings by 3. If not, then we will have to continue this again. We'll also take a longer break for lunch. Are there any questions on our procedures today, beginning with the petitioner?
No questions from petitioner. Thank you.
DPP,
No questions, thank you.
OPSD.
No questions, thank you.
Thank you. Commissioners, are there any further disclosures to make regarding this docket? Note that I believe the additional witness added to the Kamehameha Schools witness list is the wife of a high school classmate of mine. not one of the high school classmates who bullied me, so I'll continue to be fair and impartial on these proceedings, but I just want to throw that out there. And if there's any concerns from the parties, I'll hand it over to Vice Chair Giovanni to proceed over any objections. Hold on, we're getting some audio feedback from OPSD. Fellow Iolani person, you must have felt for me. So, any objections or concerns with my disclosure, starting with the petitioner?
No concerns, thank you.
Thank you. DPP,
No concerns, thank you.
OPSD. Of
No concerns, thank you.
course, the difference between Brian and I is that he went there when it was only boys. So,
Mr. Chair,
Commissioner Wong,
question about the witness is it on our list or was
she is
it?
on the list, which we have not yet accepted.
Thank you. Just wanted to be,
I said preemptively.
thank you, Chair.
Anything else, commissioners? Any disclosures? If not, Ms. Quinones, written testimony.
Good morning,
You
Chair.
can speak directly to the microphone, Ms. Quinones.
Good morning, Chair. This is Natasha. We received two additional testimonies. One is Garrett Matsunami from Castle and Cook, Hawaii. And the second one is Stanford Carr from Stanford Carr Development LLC.
And those have been posted.
They have been posted to the website.
Thank you very much. And I'll deal with the admission of exhibits. Ms. Lamb, you have additional exhibits you wish to enter into the record?
That's correct, Chair. Jennifer Lynn speaking from Kamehameha Schools, and we submitted exhibits 42 through 47, as you noted earlier. Some of these materials are materials that had previously been submitted in this docket, but we provided them again in light of some of the questioning that came up last week. Some of the materials are newspaper articles that came out after the last master plan hearing that we had in, I believe, this very room, and then an updated master plan PowerPoint presentation and an updated Gantt chart, again, all in response to questions from commissioners. So we would ask for those to please be admitted into the record.
Thank you, Ms. Lim. Any objections to the admissions to the record? County,
No objections, thank you.
OPSD,
No objections.
commissioners, starting with the ones physically here. Commissioners Giovanni or Okuda, any objections? Seeing none, petitioners' additional exhibits are entered into the record. County, any additional exhibits?
We don't have any,
I can no longer hear you. I don't know what has happened.
no additional exhibits.
Thank you. OPSD.
No additional exhibits.
With that, we can continue, Ms. Lim, with your presentation.
Thank you, Chair. So when we broke from the last meeting, my recollection is that Mr. Jason Jeremiah, our expert in traditional and customary Hawaiian practices, had gone through direct project examination. And I don't believe the other parties had questions for him, but commissioners had questions, and there might be the possibility for redirect. So therefore, I would ask that Mr. Jeremiah wanted to continue with questioning from commissioners.
Thank you, Ms. Lim, and my recollection jives with yours. Mr. Jeremiah. Even though we could say that you are still under oath, I'm just going to swear you in again. Do you swear or affirm the testimony you are about to give is the truth?
Yes.
Okay, let's see whether we can get the mic, you and the mic closer together. Let's just, Jason, if you could just do it, Mr. Jeremiah, if you could just do a test. Speaking of testing. Can I come closer to you? Like you're almost kissing us. There you go. That's better. Okay. Are there questions for the witness, starting with DPP?
I have no questions for him, thank you.
OPSD.
No questions, thank you.
Commissioners, questions for Mr. Jeremiah? Commissioner Chang.
Good morning, Mr. Jeremiah. Good to see you this morning.
Good morning.
I just have a few questions. And I appreciated the work that was done. There was a lot of good work, a lot of reaching out to people now, so I thought you did a really good job. But these questions deal with, if you could describe for me the use of the property prior to the plantations. As far as that is pre-contact, if you could describe that, because I did not see a lot of descriptions about that. And I know there was a lot of discussions that as a result of the plantation, a lot of those resources may have been, or there was no evidence of. So if you could describe the activities of the property prior to Western contact.
Thank you, Commissioner Chen. When you look into the written record, the oral record from our kupuna through various archival sources, and just understanding traditional land uses of Ahupua'a, especially in the Ewamoku, the area of the proposed project, this middle area of the Ahupua'a Waiawa, was not an area that was heavily inhabited. It wasn't heavily used. There was traditional trails that were documented by John Papa'i'i and some of his works that may have been pretty close to the area, but they were trails that kind of where the present day Kamehameha Highway would have been, and kind of there would have been a thoroughfare that went up to the North Shore, another royal center connecting all the various populated areas. But and when you look into the Land Commission awards that were awarded and claimed during the Mahele in the 1850s, you see the concentration of the habitation, the use of the Ahupua'a in the lower area, below the current day Leeward Community College. There were local I'a, Lo'ikalo, local Lai in those areas, and you didn't see any claimants in the area of this of the area we're talking about in this petition. So that's generally my understanding through my research of the area, and there through our archaeological work, we haven't uncovered any significant Hawaiian sites in this area. We've gone through there, numerous archaeologists, a lot of plantation, but I would say that we wouldn't suspect a lot of traditional Hawaiian sites in the area of the petition area.
Thank you for that description. In many instances, traditional customary practices is primarily the right to access. It may not be, as you say, a place where there was maybe habitation or where there may have been actual use, but it may have been especially your mention of trails, that it may have been an access with reporters or running Maka to Makai, so that people could get access from where they live, perhaps at Maka. Could you elaborate further on this trail system? You said there was one that is currently the present Kamehameha Highway. Any other trails within this property?
Within the property, I haven't seen any documented trails specifically in the property. And there have been trails more north of the Ahupua'a Waiawa that are where a lot of the public hunting area is located. But within the specific Ahupua'a, I haven't seen any documented trails in those areas.
My final question is, within this area, are there known to be any resources that may have been used for gathering, whether they're for medicinal purposes or subsistence? Are you aware of any kinds of resources that may have at one time been in this area?
I'm not aware of any of those traditional resources, whether it be plants and so forth in this area. It's, as you've kind of mentioned as well, the plantation came in and there's been a lot of impact, and we haven't seen any Hawaiian plants in this area.
And this is just to confirm that Interim has not received any requests by Native Hawaiian practitioners or families to access the area since the time that, as far as you're aware of?
As far as I'm aware of, we took back more control and management of this property area around 2010, 2011, and we haven't, to my knowledge, received any requests of that nature.
I'm notorious for always saying this is my last question that I have to say. But I think this is my last one. And I have greatly appreciated just your ability to respond almost intuitively to the questions that I asked. So clearly you have a good understanding of this property. However, in the future, if a family member come forward and ask them in their schools to have access or can demonstrate that they have a relationship to the property, would Kamehameha Schools be adverse meeting with the family to discuss a reasonable access or what they're going to do?
No, we would not be adverse to that. I think we want to support our Native Hawaiian communities and families and individuals and practitioners. And yeah, we would love to kind of discuss that with them if they would come forward.
And I appreciate that as well. As land stewards, especially Kamehameha Schools, where you have such an important kuriana, to always keep that door open in the event that there is a family member who can demonstrate a traditional practice. So mahalo for that. And I have no further questions. Thank you so much, Mr. Jeremiah.
Thank you, Commissioner Chen.
Thank you, Commissioner. Commissioners, any further questions for Mr. Jeremiah? Seeing none at this time, any redirect, Ms. Lynn?
No redirect, thank you.
Okay, thank you very much. Thank you, Mr. Jeremiah, for your testimony.
Thank you, Chair.
Please feel free to call your next witness.
So, Chair, Commissioners, our next witness is Michelle Schwartman. And to let the cat out of the bag, Michelle is going to walk the commissioners through the PowerPoint that we filed. I think that's exhibit 46. So I do want to be mindful of Commissioner Okuda's exit time, which is in about 10 minutes. So
Yeah.
we'll run through as much as we can. That's okay.
That's what I was going to suggest.
Okay. Exhibit 47 is the PowerPoint.
Okay. So sorry, in virtual land, how are we getting the PowerPoint? Are we putting the PowerPoint up on the screen?
So I'm going to be sharing it. I'll share it on the Zoom.
Thank you, Ms. Dunn. Okay. And Ms. Schwartman, good morning.
Good morning.
Do you swear or affirm the testimony you're about to give is the truth?
I do.
Okay, thank you.
Michelle. Good morning. Michelle, for the record, would you please tell the
Ms. Lynn,
commissioners,
directly into your microphone if you can.
would you please tell the commissioners your business address for the record?
Sure, it's 567 South King Street, suite number 200, Honolulu, Hawaii, 96813.
Thanks. And I know you work at Kamehameha Schools, but would you let the commissioners know, please, what your position is there?
Sure, I work in the planning and development of the commercial real estate division at Kamehameha Schools.
And how long have you been there?
I've been there for the last 6 years and have been working in that capacity across and working on different land projects across the Ewamoku for Kamehameha Schools.
For about the last 6 years.
Correct, including Wyoming.
And Michelle, what is your professional educational background? I know you haven't testified before this commission in the several hearings we've had on WAIAWA, so let the commissioners know a little bit more about you.
Sure. So I was born and raised in Hawaii on Oahu. I attended Punahou School, received my bachelor's degree from the University of Hawaii. And very happy to be working with Kamehameha Schools. I have been in the real estate industry for the last 32 years. And I have been in land development and planning and entitlements for the last 16 years.
Thanks for that. And Michelle, you know, the reason we're here today is because we filed a motion. When I say we, I mean your council filed a motion on behalf of Kamehameha Schools for a motion for modification, time extension and release and modification of some conditions. We filed that in December 2021. Would you let the commissioners know if you're familiar with the contents of that motion?
Yes, I am familiar with them and have reviewed the files along with the appendices that were attached to them.
Now, Michelle, for the record, did you attend the hearing that we had on March 23rd, the first hearing on this motion?
I did, but I did not provide any testimony.
So you were in the audience.
I was.
What was your takeaway as you listened to the hearings and especially the questions that came from the commissioners?
I guess as I was listening to the testimony and the hearing, it became apparent to me that there was some confusion over the WAIAWA master plan and the solar uses as an interim use. I think there was a little bit of confusion as to whether or not these solar projects would hinder the development of future homes at WAIAWA. And I hope this presentation that I'm hoping to present to you will, add more clarity to that and instead describe how, in fact, the solar development is in synergy with the WAIAWA master plan that we presented in 2020.
So with that, Michelle, I know we have exhibit 46 up on the screen. Why don't you, excuse me, I've done it again, exhibit 47. It's a PowerPoint presentation. Why don't you go ahead and walk the commissioners through that, and I'll ask you some questions as we go through it as well.
Okay, and
And
I
just
also,
don't be afraid to project,
okay.
both of you, please. Thank you.
So I also want to note that we submitted exhibit 48, which is a Gantt chart as requested, I think, by a commissioner last time. So we have submitted that as well.
And Michelle, you and I think, have mind meld because we keep messing up exhibit numbers, but
Yeah,
for
I
the
see.
record, the Gantt chart is actually exhibit 46, and
Oh,
the PowerPoint is exhibit 47. But it's noted, a Gantt chart was submitted in response to comments from commissioners.
Yes. I think we can turn to the next slide, though. So, you may recall in 2020, my colleague and the managing director for commercial real estate, really my boss, Walter Temes, presented to this commission in January, I believe, of 2020, and he presented our WAIAWA master plan. And the master plan vision has not changed since then. We continue to pursue, and while it's ambitious and it will be a long and arduous process, we are continuing to strive for the vision of WAIAWA community to include culture, to include housing, the much needed housing, and rail, as well as solar as an interim use. So collectively, we do think that there's an opportunity using our lands and our INA at WAIAWA.
So Michelle, you mentioned Walter.
Can I add one more thing?
Of course.
I'm sorry. I also want to just note that, our Kamehameha Schools has an obligation to our beneficiaries, and in all decisions that we make with our INA Kauai, we have to make sure that it makes economic sense. And so through those lens, we're able to provide in perpetuity for our beneficiaries. So it's not for our beneficiaries today, but it's really the kinds of decisions that we make that are hard and long really affect our beneficiaries in the long term. So it's not for just today, it's for generations to come. Sorry about that.
No, those are important points. I'm glad you interrupted me. Coming back to sort of the technical details, why did Kamehameha Schools submit a master plan
to the commission. I believe it was submitted in 2019 and then a presentation was done, and she said by Mr. Tamas in January of 2020. Why was that done?
In the 2014 decision in order authorizing Kamehameha schools to use our lands for solar as an interim use required that Kamehameha schools goes back to the commission with a revised master plan within 5 years of that approval, which in 2014, 5 years from then, 2019. So I believe it was condition 1 that we were satisfying, and that was the reason why we presented it to the commission in 2020. I believe we submitted our motion in October of 2019, but eventually made our presentation in 2020, January 2020.
That's correct. So, and just for the record, the master plan submittal that was made in October 2019, another copy of that's been filed. That's Exhibit 42. Is that correct?
That's correct.
And then Mr. Tamas's PowerPoint that he gave to this very commission in January, that's refiled as Exhibit 43.
Yes, that's correct.
So, Michelle, you're going to do this way better than I can. Why don't you give the commissioners a refresh? I mean, they've already heard all about the master plan, but give them a refresh. Going back to your opening point, which is there seems to be some confusion. We just haven't explained things well enough.
Yeah, well, what you see on the screen here is an overview of our WAIAWA master plan. It may seem familiar to you. The actual map that you see to the right was presented to the commission in 2019, and Walter did speak to it. But so just to kind of give folks a reminder, another overview of the land plan. Our land plan remains the same. Today, it covers approximately 2,010 acres. There's going to be various uses across the lands here that you see. It will include housing, open space, schools, parks, commercial uses. What you see as noted in the star, that location there marks the area where we intend to start our land plan and our WAIAWA community.
Michelle, I'm going to stop you there. I know we've always indicated since 2014 that Kamehameha Schools was intending to start development from the south. But let the commissioners know why, what's the thinking behind that? Why is it important, or why is the decision made to pursue development starting from the south?
Sure, so our plan differs from the previous plans that have been approved in the past. Primarily, the reason why we are starting in the southern Makai side of our land plan is because, one, it's closer to the Crow Highlands Transit Station. And secondly, it's closer to the existing infrastructure.
By infrastructure, do you mean
sewer, roadways, and water as well.
So there's a better ability to actually connect to existing sewer infrastructure if you start building roads.
And we felt that it was just, we constantly look for ways to be more efficient in our planning process. And so, instead of bringing all our infrastructure up to the Mount sides or the Kula area of that area, starting where there are existing infrastructure makes more sense to us.
And certainly the transit.
Yes, obviously, yes.
Component. Yeah. Michelle, the slide says interim solar, phase 1 and phase 2, and it's going to be 66 megawatts with a combined 384 megawatt hours of storage. What are you talking about when you say interim solar? Where's phase 1 and where's phase 2?
I don't know if you can see it as clearly on this screen, but you can follow along. And my apologies if it's a little small, but so there are 2 solar projects at WAIAWA, which was approved in 2014. And the area to the right, which is dashed in pink, where that hand is encircling right now, that is what we call the WAIAWA solar phase 2. That's a solar phase 2 site, and that currently is being constructed by Clearway, and where this commission approved that solar project in 2020.
So I'm just going to interrupt you again. I want to make sure that we're very, very clear. So the site that you're calling the phase 2 solar, where the hand is on the screen right now, that was approved by the commission for solar use in 2014.
Yes, that one, both projects were approved in 2014 as an interim use.
And then the phase 2 solar site was approved again in 2020?
That's correct. I think there are some modifications. The solar, WAIAWA solar phase 2 site where that hand is to be commissioned by 2059.
At the latest.
At the latest, based on, with the caveat that there's some conditions to be met, but at the latest, it's at 2059.
But is that?
Chair, I'm sorry, Chair, this is Gary Okuda. May we take a break at this point?
Yes, reconvening in 25 minutes, half hour?
Yes, hopefully sooner than then. Thank you, Chair.
Okay, we're gonna pause right now. We're gonna take a recess. I'm not able at this time to announce how long our recess is going to be. I'm going to be texted by Commissioner Okuda when he's done with this court hearing. I'll then give people a 5-minute warning that we're ready to start again. I apologize, let me repeat. We're back in session. We are joined in person by Commissioner Okuda. I apologize to everybody for the unexpectedly long delay, and thank you. It is 10:58. My intention is that we go till noon, or perhaps if we need to go slightly beyond an hour to conclude any cross and rebut of the witness, we won't. So then we will take a half-hour break for lunch and resume our proceedings. Ms. Lim, please continue with the direct testimony of your witness, Ms. Schwartman.
Thank you, Chair. And my co-counsel, Ms. Onaonathone, is putting the PowerPoint back up on the screen. Exhibit 47, and I believe we left off on slide 3. Just let Michelle get started once that's pulled back up.
So, thank you for that. Just wanted to kind of clarify also the various phases of our WAIAWA master plan that we presented to you folks in 2020. And I know this is just kind of a recap of what we presented to you then, but the colors that you see correlate with the various phases and this chronologically. So what you see in yellow is phase A, green is in phase B, C is in brown to the left where those labels are, D is the pink area, and then E is in the most Mauka region and in purple. And I think where I left off, I was describing to you the 2 different solar projects that were approved in 2014. And the area in the pink dashed area is what we refer to as the site, solar phase 2 site. And that is in construction right now by Clearway, which you folks approved in 2020. And then in the area that you may see in the hashed red area and blue, that boundary identifies what the current motion is in front of you. And that land area in dashed area refers to what we call solar phase 1. And so solar phase 1 project occurs in 2 different phases, if you will, and it correlates with the rollout of our master plan development. So in the red dashed area, we refer to that as parcel A. And the area in the blue dashed area that covers portions of our phase D of our master plan is what we refer to as parcel B. So this map, kind of shows graphically how the WAIAWA master plan and the solar uses as an interim use is an integral part of our master plan.
Michelle, just for clarification, because you're using the term interim use, but I look at this map of the master plan and I see over in phase C and phase D of the master plan, these solar farms. So is that what you mean? The master plan and the solar farms are going to coexist from No,
immemorial?
actually, the solar uses are in interim use. So as we develop from the Makai for our WAIAWA community, as we roll up into the latter phases, the solar uses in WAIAWA Solar Site 1 or Solar Phase 1 will then be decommissioned and roll out. They will go away. Solar Phase 2 in the pink dashed area, that will remain and as we continue with our master plan, working our way from the Makai side up. So, and it's timed with what we think is the absorption rate for homes and commercial uses. And that's how we created our agreements with the solar developers.
So in your view, is there going to be competition between the phase 1 solar project, which is what we're here about today? Is there going to be competition between the phase 1 solar project and the ability to construct homes on this land?
No, no, not at all. There's no competition. It's just part of the overall plan where we optimize the ability to use our lands for a renewable energy project, and as they roll off, the master plan will continue to move upwards.
Maybe it'd be more clear if you help the commissioners understand the estimated timing of the master plan, which I think is on the next slide.
If we could turn to the next slide, that'd be helpful. Okay, so this slide speaks directly to our phasing again, just as a reminder. Renewable energy sources creates an opportunity for Kamehameha schools and has as a revenue source. And so we believe that renewable energy at WAIAWA as an interim use is just very aligned to our values at Kamehameha schools. So back to this slide. Phase A, you'll see in the pink there.
I'm sorry, can I just correct you? Phase A of the master plan, that's in yellow? Is that what you?
Yeah. So if I could go back, the red boundary bold line that you see here identifies the urban uses or the urban district at WAIAWA. And you'll see just below that big chunk, a number 1 looking boundary, that too is within the urban district. And you'll see here on both the EVA side and the Diamond Head side of our master plan, you'll see where we intend to have our renewable energy projects and our solar projects.
So please, again, explain to the commissioners what these timeframes are, where it says phase A in yellow and it lists a number of homes and then it's got years. What do those years represent?
So the numbers that you see in parentheses this time around, because just to kind of note, we presented an exhibit that had these kinds of timelines in the 2020 presentation, but this year I'd like to highlight the fact that these timelines are in response to this commission's requirement for us to complete the phase A backbone infrastructure by 2030. So these dates here, as in phase A in yellow, 2031 to 2040, respond directly to, they reflect the vertical construction of homes. So obviously we have to complete the backbone infrastructure as you folks required in 2020 by 2030. So we anticipate starting vertical construction in 2031.
So then explain from phase A of the master plan, vertical construction starts, it's estimated in 2031. Then what happens after that, Michelle, in terms of the phasing?
So in terms of the phasing, we roll up into phase B, where we anticipate delivering 2,300 approximately homes and starting construction, vertical construction in 2038 and delivering throughout phase B up to 2048. And then the same goes with phase C, D, and E. And again, just as a reminder, solar phase 1 parcel A will decommission by 2044.
And then phase 1 solar parcel B will be decommissioned by 2054 that you see in pink, that D area of the master plan.
So just to be real clear, the solar farm that we're here about today, the phase 1 solar, the portion that's within the phase C of your master plan, that's going to be decommissioned no later than the end of 2044. And you anticipate vertical construction in phase C of the master plan to begin when?
In 2045. I'm sorry, I can't barely see that, but
I think it says 2048.
2048, yes, sorry, 2048, 2060. Sorry, it's so light on that.
It is light on the screen. Okay, so again, do you see that there's any competition? Is the solar farm, phase 1 solar farm in any way delaying, inhibiting, restricting?
No, not at all.
Master plan.
Not at all.
You know, keeping track of all the phasing and names and developer names is a little bit confusing. You've managed it real well. I guess maybe we'll just acknowledge that it's difficult when there's different phases, different parcels, and maybe assure commissioners that you're prepared to answer any questions in that regard.
Yes, I think anytime in planning, there's difficulty in proper labeling. I mean, you do that so many times and often, but yes, I think it's a little confusing with regards to the phasing and numbers, but just to be clear, the motion for phase 1 solar, that's the 387 acres in the 387 acre area that this commission approved for the interim uses in solar phase, in interim uses in 2014. So both areas for solar phase 1 and solar phase 2 were both authorized in 2014 decision in order.
Is this motion requesting any additional land for the solar farm than what was already approved by the commission in 2014?
No, not for the solar farm at all. No.
If I may, I think some of your points are more on slide 6 of your exhibit. What you're talking about doesn't seem to be a little more.
They'll continue. We do want to make sure that everybody can follow the facts, even if sometimes it seems like they're a bit redundant. So coming back to what we have in front of us, which is, I believe, now I've lost my track, but we have slide 3 or slide 4? This is slide 4. Okay. Now, you explained to the commissioners why phase 1 solar, the one that we're here about today, is split into parcel A, parcel B, and that's to make way for the master plan.
Correct.
Now I see that the phase 2 solar, which we're not here about today, but we want to make sure everybody has a complete picture of what's going on this property. Why isn't that split into parcel A or parcel B or somehow split up into different little pieces?
So solar phase 2 sits within the zone of contribution. And so there's no urban uses that are contemplated within the area. So there was no need for them to make way for our master plan development. The commission authorized them to be there until 2059, granted again, should they meet the various conditions of that DNO in 2020.
Gotcha. So, I mean, there's not going to be, at this point, anticipated development going on in that area anyway, whereas for phase 1 solar, it is anticipated for development. Michelle, switching gears, also on this slide though, you explain what the red bold line means, and that's the 1,395 acre existing urban district land. But then up at the top, you've got some other notations about land, and you said the master plan itself covers about 2,000 acres. So I don't know if you want to talk to that issue on this slide or the next slide. But just explain that for the commissioners, please.
Yep. So the 2010 acres that I mentioned earlier that the WAIAWA master plan will cover consists of the 1,395 acres that we have currently in the existing urban lands, and we will seek, based upon the existing master plan, an additional 476 acres for reclassification. And then the lands to be retained in ag is about 130, again, I can't see that either, about 139 acres, but okay, thank you. We can move to the next slide. I think this helps to describe graphically what I'm talking about. So this slide, slide number 5, again, speaks to the various lands that are in urban district. So the red boundary, red bold line that you see there indicates the current 1,395 acres that are in the urban classified district. The areas that you see in hashed and labeled where it says there are portions of phase A of 71 acres that we would need to reclassify. In phase C of our master plan, we're looking to reclassify approximately 114 acres. And then in the upper areas of our master plan, our proposed master plan today, we're looking at reclassifying 251 acres from ag to urban. Yes.
291.
291. I should put my glasses on, sorry. Yeah, so collectively that makes about 476 acres.
So Michelle, I know we're discussing the master plan and yet you're talking about reclassification. Now, I heard one of the commissioners raise a question at the last hearing. If this master plan is premised upon a reclassification, how do we know that it can go forward? So what happens if the commission decides not to grant that reclassification?
We have a very long road ahead of us. We have a number of steps to take before we even ask the commission to grant a reclassification. So, I think the biggest step for us at this point would be satisfying the environmental impact statement for the entire WAIAWA master plan. I think it's premature at this point to really know what the alternatives are that we evaluate during the EIS process, but one of the possibilities is that we could have an alternative that shows a smaller WAIAWA master plan than what we show today. We just need to go through the process of understanding the impacts of the various alternatives through our EIS process. We just haven't gotten there yet.
Understood. So whether ultimately this commission is asked to reclassify additional lands or not, it's not known at this point. But in an effort to be transparent, you're describing, sort of the master desired vision for WAIAWA, and then the hard work has to get done.
Yes, and assuming that this is the land plan that we select and go through our EIS, we obviously will have to look for a reclassification of lands. But at this point, we don't really know what all those alternative plans look like.
And even setting aside a question about reclassification, let's say ultimately the WAIAWA master plan is retained entirely within the existing urban district lands and maybe some adjacent agricultural lands that you plan on keeping in agricultural district. Would Kamehameha Schools have to return to this commission to get permission to go forward with that project?
Yes, so there are, I think actually, I think the next slide will describe to you, well, maybe we can jump to the next slide first before I answer that question.
Sure.
That's slide number 6. This is just kind of a reminder of, again, I'm sorry if I'm repeating myself over and over again, but we just wanted to be crystal clear that, this is, again, just this slide number 6 describes the urban boundary. It shows where the phase 1 solar, which is who through our partner AES would develop these areas of parcel A and parcel B, and phase 2 as solar as Clearway. And just as a reminder again, Solar phase one, parcel A is to be decommissioned in 2044, and then parcel B decommissioned by 2054. And then lastly, phase two Clearway Solar will be decommissioned in 2059 for the LUC in 2020. So I'm sorry again, my apologies for being repetitive, but thank you for bearing with me. We can turn to the next slide if you don't mind. So this slide describes in chronological order the our solar approvals. And again, this might be a little redundant. Just wanted to remind you all, in 2012, KS regained control of our WAIAWA lands from the Gentry development. And then just 2 years later, we went to the State Land Use Commission and they approved the solar as an interim use until 2049. And then even 2 years after that, unfortunately, Sun Edison, who was a large company, filed bankruptcy, and the WAIAWA lands returned back to KS once again.
They were a publicly traded company, is that right?
That is correct.
So had KS done its due diligence to determine if Sun Edison appeared to be a reputable and capable developer?
Yes, at that time, we were definitely confident in their ability to deliver the solar energy as an interim use at that time.
I think a lot of people were surprised.
Yes, unfortunately. However, though, in 2018, ECO distributed a request for information, and KS responded to that request because we felt that there was an opportunity for KS to use our INA for renewable energy and to support the state in their goals for renewable energy by 2050, 100% by 2050. So, and then we went back to you folks again in we submitted our motion to amend in 2019, and this commission approved and reauthorized the use of our lands at WAIAWA for solar as an interim use once again.
So in the 2019-2020 motion on the phase two solar, did Kamehameha Schools alert this commission that we would be coming back in fairly short order to request reauthorization for the phase one solar site?
Yes, in 2020, we did notify the LUC of our intent to come back for the use of the other solar site and for their authorization again. And thus here we are today. But I also want to note here that you'll see in the slide that in 2020, the commission also imposed a condition on Kamehameha Schools to complete all backbone infrastructure for our phase A by 2030.
And going back to 2014, and this goes to a question I asked when we were on a prior slide, but I think you justifiably wanted to move ahead. But my question was, even if Kamehameha Schools elects ultimately not to pursue a district boundary amendment, so the master plan stays entirely within the existing urban land, does Kamehameha Schools need to return to the Land Use Commission to get authorization to go forward with that master plan?
Yes, the answer is yes. We do intend to come back to the State Land Use Commission for a couple of reasons. One is, what was authorized in 2014, or excuse me, what was authorized for Gentry's urban reclassification is quite different. What they represented back then is quite different from what our land plan shows. At that time, Gentry proposed 2 golf courses. They also proposed use of their lands for age-restricted housing. And whereas our land plan is quite different. One of the ways that we're quite different from the Gentry plan that is in place today is that we intend to start at the very Mackay area, which is 1. 2, we envision a place where we have multi-generational homes and residents living there. And 3, it's just something that's very different than what was proposed by Gentry. And our land plan also is really in sync with obviously the solar, but also we wanted to have a connection to the rail transit station there at Pearl Highlands.
And correct me if you think I'm wrong on this, but in 2014, did the commission not impose a condition on Kamehameha Schools that it couldn't do anything other than interim solar until such time as it filed a motion to amend and got approval from this commission to do so?
Yes, so I believe one of the conditions is that we need to present a revised master plan upon decommissioning. However, you know, our plan was never to just sit on this land, even though there was solar being used, being constructed and developed on this land. Our land plan, you know, Kamehameha Schools plan was always to evaluate these lands for opportunities for housing and commercial uses. So we anticipate, given, assuming that it's the land plan that we presented already, we would need to come back to the Land Use Commission for a district boundary amendment. And then shortly after that, we would have to come back and make a motion to amend based on the different projects and what was represented by Gentry and what we propose today.
Should we turn to the next slide, which I think gives the commissioners a sort of a high level walkthrough on the next steps, kind of the short-term plan, and then we can talk more about the longer-term plan after.
Yes.
So we're now on, I believe it's slide 8.
Yes, and I won't read each box here, but this is our roadmap of the WAIAWA Master Plan entitlements and our process. I think, well, the entitlements are what they are, and there's no way to avoid or accelerate the entitlements process. But we expect it to be long and ambitious and costly and arduous. But you know, again, we plan to go back to the State Land Use Commission at the very milestones that you see here marked in the red star. These are the initial steps that we need to take to even consider delivering any houses.
What are those steps? I'm sorry to interrupt you. I agree. I don't think anybody wants to hear you read everything in every little box, but we keep talking about a motion to amend and possibly a district boundary amendment. At a high level, what are a couple of external steps that would have to happen before a motion to amend gets filed?
Well, you're asking what happens before that second star?
That's right.
So we have to go through our EIS process. You know, we've identified PBR as our consultant to guide us through this process. So obviously with the EIS process, we have to, you know, community outreach and engagement plays a huge role in that EIS process. And then that will start and be continuous and ongoing for quite a number of years. And then we have to understand who the appropriate EIS accepting authority is. And so we have to coordinate with the various agencies to understand, you know, who that agency will be accepting our EIS. And then you know, we also need to file our prep notice and the publication of it, and then anticipating the 30-day comment period. And then, you know, and I think you guys can all read the individual boxes and the different steps in each of these milestones. But, and then of course we need to go through the draft EIS, public comments again, and then prepare the final EIS and submit the EIS to the accepting authority for action. So we have a long road ahead of us. And I mean, again, like I mentioned before, there's no way that we want to accelerate this entitlements process. I mean, we'd love to if we could do that, right? If we could get right to it. And I mean, and that's the plan is, you know, right after these proceedings, we plan to get into our EIS and satisfy that entitlements milestones.
For clarification though, PBR Hawaii has been retained. Yes,
Thank you.
yes, they have been, they have actually helped us identify what those next steps are. They're helping us to create a plan for outreach and engagement. You know, we selected them based on their experience on a number of EISs and across the state. So I think we're pretty satisfied with who our consultant is.
Thanks, Michelle. And just a couple of more questions on this slide, and then I don't know if you'll have anything that you'll want to add, but I noticed at the bottom, there's discussion about rezoning, going to planning commission, then eventually going to city council. Now, as this commission and all the parties know, exhibit 3 that we filed shows that this property is rezoned. So when Gentry had it, they pursued the reclassification, and then they went and they got it completely rezoned from the city. So why is there rezoning listed here?
So what Gentry proposed as zoning, again, like I mentioned, is very different from what we propose. They, in their plan, included industrial and as well as residential. But, you know, the location of where those uses are proposed from Gentry is again different because we're starting at the lower region. And our plan, our Kamehameha Schools plan today is much more in dense. We look to find more efficiencies and increase density within the WAIAWA plan.
Gotcha. So the land already has zoning for development, but in pursuit of the master plan, that zoning needs to be changed.
Yes, and granted, I'll also note that Gentry also completed an EIS, right? But we don't, and I mean, we plan to complete our own EIS, go through our own zoning process to ensure that we are doing it the right way and it is relevant to what Kamehameha Schools is proposing versus another project or developer before us.
Thanks, Michelle. Last question on this slide, and it's not really something we need to sit on the slide for, but you've got 2027 for subdivision. So that's actions through the Department of Planning and Permitting. So boom, 2027 estimated date, then what construction happens 2028?
Actually, we can, if you don't mind, can we turn to the Gantt chart that we submitted? That was the the timeline, in like better detail.
Exhibit 46, that is.
Yes, sorry, exhibit 46.
Challenge.
Sorry.
Just if I could, we do have large printed hard copies. If there's anyone, any parties or commissioners.
If the witness would specify what you're hoping to illustrate on the Gantt chart.
So what I was trying to share with you all is how shortly after our zoning completing our zoning process in 2027. I can't even see that myself. I'm sorry. I was hoping to share with you all how shortly after that we would be starting our construction of our backbone infrastructure and how it rolls into the vertical construction and timed with the phase A. I think just kind of a big overview. This Gantt chart shows our overall planning and the various milestones of our EIS process, the petition for district boundary amendment, and then the file to motion to amend.
Sorry to interrupt.
Yes.
Just as we're staring at the Gantt charts, which are challenging to read even if you have them physically in front of you, can you just jump to what specifically are you trying to convey to the commission?
I guess what I'm trying to say is that this process is going to be long and arduous. We're going to meet, we're planning to meet our milestones of shortly after our subdivision, going straight into our backbone infrastructure and starting vertical construction shortly thereafter, 2030.
I think that point is well conveyed via words and perhaps better via words than the Gantt chart.
Okay, again, I just wanted to make sure that we acknowledge this Gantt chart that was requested by one of the commissioners last hearing. And satisfied that.
Thank you very much.
And again, I think part of the Gantt chart communicates, people will read things differently. Some people are words, some people are pictures, some people are charts. But if there are any lingering concerns that this phase one solar would delay the building of homes in the area where the phase one solar has been approved, maybe that's communicated in the Gantt chart as well. You can see where the solar is and how the phase C development doesn't even get underway until after the solar is removed. Thank you. But we won't beat that horse any further. Is there anything you want to bring the commissioners back to within the PowerPoint, Michelle? I know you've got a slide update on the diligence work that's taken place.
If we can have slide 9. I just kind of wanted to speak to this presentation and share with the commissioners all the different things that Kamehameha has done over the last couple of years. Sorry, just give me a moment. Okay, I get out of this.
The diligence items that we're going to see in a moment when we get it on the screen. Is this the collective diligence efforts, or is this just merely what has been done since Mr. Tannis's presentation in January 2020?
Yep. So
just an update.
This is an update. So since the 2020 hearing and the presentation by Walter, my colleague, Walter Temis, these are all the different tasks that we've had, we've completed over the last 2 years over COVID. The last time we were here, we submitted a long list of actions, but this time, all these tasks that we've been addressing over the last 2 years really is, we heard you folks and the importance of meeting that 2030 deadline of all our infrastructure for phase A. And so we took it upon ourselves to get right to it. And we started working with different agencies and addressing infrastructure capacity and agreements with the city and state. And you know, these are all the things obviously that would need to be done even before we started considering delivering any homes. It describes the various actions, who we've been working with, who our consultant is to help guide us through that process, and some of the outcomes over the last 2 years since we presented to you folks in January 2020. Aside for the things that you don't see, we've also updated our residential demand study. We've engaged the traffic engineer at Wilson Okamoto for an updated regional traffic impact assessment. And then we've also worked on deregistering a portion of our WAIAWA lands from land court to the regular system. So we haven't been sitting idly over the last 2 years while the world adjusted to COVID and the impacts from COVID. We've been quite busy addressing access and sewer and water. And again, we've also worked internally to refine our own master plan that we proposed in 2020 to ensure that it is fiscally sustainable and viable at the same time. And then what you see here, we've completed, or we've also engaged EIS. I added that to the list as well. So, Michelle, I know also what I see even from this slide and what you just said, that work toward the master plan has been underway. But a lot of this is kind of technical work. It's figuring out how to make the infrastructure
feasible. It's, you know, where can you connect to sewer and how can you connect to sewer? But I'm not seeing community consultation here. Now, I know in the last presentation, there was a long list of meetings that had taken place with stakeholders. How come we're not seeing community consultation on this chart?
Yes, I guess for before Walter Temis presented in 2020, we had completed significant community engagement, consultation with the state and city agencies, some of which are here today. But we knew that while we anticipated doing more by the time we came back to you folks for solar approvals for the reauthorization of solar phase 1, we knew that through our EIS process, we would again do a huge amount of community engagement. As you know, that process is going to be long and lengthy, and you know, we anticipate getting right to it as soon as we're done with these proceedings. Have we done as much as we expected and anticipated? No, but we do anticipate, you know, a much more accelerated outreach once we start our EIS.
And by the master plan refinement and financial feasibility work that's been done with DPI, that was really trying to figure out how to make the master plan pencil.
It was really about looking for ways to be way more efficient with our infrastructure, with our roadways, our wastewater. You know, we've met with the city environmental services to look for opportunities for existing capacity that they may have. So yes, every step of the way, and it is our obligation to make sure that what we present to our own leadership and our beneficiaries makes sense. And I think I mentioned that in the very beginning, is that whatever we do, and however we assess our lands and how we propose our lands to be used, we have a fiscal responsibility to make sure that we're making the best decision for our beneficiaries.
You don't want to run off kind of half-cocked doing consultation until you've done some of the hard
and
homework.
The work that we've done through this whole process of working on finding efficiencies and working with the different agencies is to make sure that we have that information when we're asked by our alumni association, who are some of our stakeholders, or the Native Hawaiian community organizations, when they ask us questions about our proposed, you know, master plan, and we want to make sure we have the correct answers to the best of our ability, and have those facts clear.
So this kind of maybe not very sexy, but important internal diligence work is, you felt it was a necessary
I
prerequisite.
find planning quite sexy, but that's okay.
So just, you know, I've come just about to the end of my questions. I do want to touch on estimated cost figures, because as the commissioners and other parties may recall, Mr. Temis estimated that the infrastructure alone would cost like $630 million for this project. That number still ringing true, Michelle?
I wish it were. The more we are delayed, the higher the cost escalates. And today we anticipate upwards of $65 million for infrastructure. And that includes on-site and off-site improvement for roadways, for upsizing of wastewater facilities. So that includes all of the infrastructure for the entire project on and off site, what we know today.
Thanks, Michelle. I feel like we've gone through a lot of the master plan, and I guess I just want to bring it back to what we are here about today, which is the motion that we filed in December for the reauthorization of phase 1 solar. Do you have any final comments on that?
You know, I reiterated, I hope that I've cleared the confusion that there might have been with regards to solar, you know, taking place and being in competition, if you will, as Jennifer, you mentioned, with the master plan. But on the contrary, the solar plan has always, the solar developments on our project sites at WAIAWA has always been a complementary use and as an interim use for a master plan. So, you know, I respectfully hope, you know, request that this commission approve the motion before you folks and motion approve the request to modify the 2014 decision in order to authorize the use of, you know, WAIAWA Solar Phase 2 LLC's AES's project over our solar site 1.
And just to be real clear, in 2014, the commission already approved the use of the phase 1 solar site until November 2049, I think it is. So when I look at your slide, you're saying that parcel A is actually going to be decommissioned 5 years earlier than what the commission has authorized. So it's parcel B that's going to be decommissioned 5 years later.
Correct.
I don't have any further questions for Ms. Schwartman.
Thank you, Ms. Lynn. It's, yeah. I'm sure that having listened to the presentation and knowing my commission, I'm sure that we're probably going to need time with Ms. Schwartman beyond what we can do before lunch. So let's go through what we can and then try to take a break in here for half an hour. Questions for the witness from the Department of Planning and Permitting?
No questions, thank you.
Questions from the Office of Planning and Sustainable Development? And actually, okay, we're off share screen. Thank you.
Thank you. I do have a few questions, and hopefully there'll only be a few. I want to make sure I understand. Any solar that will be constructed will be outside of phase A, correct?
Yes, that's correct. There are no solar uses within the master plan phase A.
And would the commissioning or decommissioning of the solar have any impact or any direct impact on the timing of development within phase A?
No impact at all.
But you will need to come, in order to develop in phase A, I think you've testified that you will need to come back before the Land Use Commission at least for an amendment to the conditions, if not also for an additional amendment, district boundary amendment for additional lands.
That is correct.
And in order for you to come back before the commission, you also need an EIS completed before that.
Absolutely.
Okay, then let me focus on the EIS. As I understand, as we move forward, sometimes it's difficult to tell exactly what's going to happen. So let me focus on this year. What do you plan to do this year to move forward with the EIS?
So this year in that milestone table slide that I shared with you all, we're looking at commencing our outreach, community outreach engagement. And then the next step would be, you know, obviously we have to understand who the accepting authority is for our EIS. And so working with the various agencies, even with you folks or LUC or DPP, to understand which of you are going to be the accepting authority of our EIS. And then shortly thereafter, we would be dropping our prep notice.
And if you could be a bit more concrete, what do you mean by outreach? What do you intend to do for outreach this year?
So there are a lot of stakeholders that we've already identified. Aside from, you know, working with the state agencies on pre-consultation, we look to working and meeting with our neighbors at WAIAWA. Those would include the various neighbors within Mililani, WAIAWA, Pro City Highlands, because they look directly at our property. And then YPO, there are a number of stakeholders. And I think included in that would be the Native Hawaiian communities. I mean, we really need to vet any kind of development at WAIAWA to the community. So neighborhood boards, business associations, practitioners, alumni. We want to talk to others about the various demands and what they see, what are their concerns, what are some of the issues that they may have. I mean, these are all the processes that we have to go through as part of our EIS anyways, and understand what those impacts are. We'll have to talk to some of our sub-consultants. Obviously, we have to complete a traffic impact assessment. We have to do a biological study. We're engineering. And not only will we be engaging a number of consultants for those reports and studies that make up the EIS, we'll be doing that to assess a number of alternative plans, a number of different variations of what our plans are. So it's an extensive process that I think you may already know, but just to highlight it, like I said, we have a long road ahead of us.
So prior to the publication of the preparation notice, this year, if I want to make sure I understand, you intend to have a meeting with all of the relevant neighborhood boards?
No. That's over the course of, over the course of the whole process. This year, I think it's about kind of laying the groundwork for ourselves, identifying who are all those stakeholders that we should be consulting with. That's first and foremost. And then we just get going and we work on that list moving forward. I can't say we're going to have 100 meetings by December 31st of 2022, but I can say that we would be making good faith efforts to talk to as many people as we can in the next 8 months.
Are you not yet ready to, do you not yet have a plan on your community outreach for 2022? Is that something still to be done?
That's in draft form right now. That's one of the scope of work that we've engaged PBR to help us identify what does that outreach plan look like.
Okay, so in the remaining roughly 8 months of the year, you will have to finalize that community outreach plan and then begin the meetings that you have described?
Yes, absolutely. I mean, even for the 2020 presentation that we had completed, we did speak to a number of different stakeholders. We've met with our Aina Ulu education partners that exist in the lower regions of our lands. We've met with the various chancellors at LCC and their staff and their administration. We've met with UH West Oahu. We've met with the Pearl City Highlands neighborhood board president, and so we've given a presentation already once before to our Kamehameha Schools Alumni Association representatives. So, and we have a long list of stakeholders that Kamehameha Schools already relies on for feedback on anything that we do. But that said, we have, we anticipate doing a much more exhaustive round and outreach program.
And after you finish this, then you intend to issue the prep notice? Is that right?
Once we know who we're submitting it to, yes, and yes.
And do you anticipate that prep notice won't come out until 2023?
We're hoping that it will be, we'll be able to drop that by the end of this year, if not early 2023. That is correct.
In the Gantt chart, it seemed to indicate you have allocated up to 4 years for the EIS. 2022, 23, 24, and 25, I think. The Gantt chart, however, lists them in total years, so it might not be all of 2025, for example. And if I misread this, let me know. Do you think this is, let me put it this way, it seems a little long to me, even for an EIS of this scope. Can you explain why it came out this long?
This is our best guess as far as how long it would take. If we could accelerate that, we definitely would want it to be accelerated. I mean, obviously, we are aiming at satisfying the condition to complete our backbone infrastructure by 2030. And before we do that, we have to complete our EIS. So yes, does it look long? Would we hope that it takes 4 years? No. But a project of this magnitude to deliver over 11,000 homes, we don't take lightly at all.
Do you anticipate hiring your sub-consultants this year?
We do. Well, PBR is our prime, and and the sub-consultants are a sub-consultant to PBR, not to Command Mass Schools.
Sorry, do you anticipate PBR will hire their sub-consultants by the end of this year?
Yes.
And then do you anticipate that the sub-consultants will begin their work, their studies that will be necessary for the EIS?
Yes, that's correct.
And you think they will at least start in this calendar year?
No. By 2023, they would be engaged, but I really don't think that they would start their actual studies until the early beginnings of 2023.
Okay, so they will start their studies, you think, after the preparation notice?
Correct.
Okay. When you get back to the Land Use Commission, do you anticipate that you will then have a revised master plan with a revised table for the various phases in this project?
I think the answer is yes. I mean, we would have gone through our EIS process and assessed the various alternatives that we will have in that process. And then who knows what comes out of that, and who knows what kind of feedback that the community has that we respond to and adjust the master plan. So at this point, I don't know if they'll accept what we've already proposed. It really is up to the community and what their feedback is based on the alternatives that we put out there.
Well, the master plan you created was in 2019. I guess what I'm trying to say is when you get to the EIS and draft EIS, you'll have in that draft EIS a proposal, obviously, that has to be analyzed. And that would presumably be the master plan, whatever master plan you're proposing at that time, correct?
That is correct.
And do you think that probably at that point, whatever that master plan is, we don't know what the details are, you have to be open to the alternatives, whatever that master plan is, it'll probably be some revision of what you than the 2019 plan.
Correct. I mean, very little.
It might contain, for example, earlier constructions of housing in phase A, correct?
Well, the construction of phase A is going to be based on how quickly we can get our EIS and the district boundary amendment, and then the motion to amend, and then zoning completed. I mean, that order of entitlements, it is what it is. And so if we can get through those entitlements quicker, then yes.
Those are all the questions I have. Thank you.
Thank you, Mr. Yee. Commissioners, we have a little while to start. I'm going to start with Commissioner Cabral. But we will try and end in a few minutes or 30-minute break.
Thank you. Hopefully my questions are really for clarification. So two sets of glasses to read all this. Thanks to Mr. Yee for some clarification, your answers provided with his questions. So your land is divided by phases A through E, but your projects are phases 1 and 2 at this point.
For clarification, when we speak to our solar phase 1 and solar phase 2, that just refers to the solar.
Okay, and solar phase 2 is already under construction and permitted, and so you put 2 before 1?
And the reason, yes, that's correct.
Okay, no, I'm okay with that. I just wanted to make sure I was clear. I'm just a simple-minded country girl. Okay.
Me too.
Oh, not as country as I. So the next thing is, right now though, in all of this talk, I mean, and so much of this wonderful plans and stuff really are talking about all these future houses. But the petition you have before us right now is only really obligating you and allowing us to work with the details about phase 1 of your solar, correct?
That is correct.
Okay, so nothing that we're really considering has anything to do with building a house.
Not at all.
Okay. My concern is that, I see all your plans and God knows you're honorable, etc. But so was the people that sat in my chair 34 years ago when we thought by now there'd be 8,000 houses on that land or more by now. And so I got and I might not have to worry about 2070. By then you'll have 11,109 homes. But that's our concern, is that we have no ability to obligate Kamehameha Schools to even one house with what you're moving forward with under this petition for the additional solar. Okay, so that's the only question I have or concern I have. Okay, thank you.
Commissioners, you're not obligated now, but just a sense of who has questions. Commissioner Higashi, Commissioner Chang, you'll have some. Commissioner Okuda?
Yeah.
Okay, Commissioner Wong as well?
Yes, Chair.
Commissioner Giovanni as well. So, okay, so did you want to try and squeeze one in before the bell, Commissioner Higashi?
No, because I'm just want to be sure I get this while it's top of my mind. Before I forget it.
Lunch should be amazing if that's going to happen, but okay.
The backbone infrastructure that you're planning for phase A, is that, and you're estimating it be taking 2 years for you to build according to this, is that based upon the existing lines or what you project to be the total phase A? In other words, you need a boundary amendment to expand the area to contain all of phase A. So the backbone infrastructure that you're planning to finish by 2030, and then you projected 2 years, is that for the entire phase A, or is that for that portion?
I think I get your question. The answer is yes. The backbone infrastructure that we plan to complete for phase A by 2030 includes the lands within the area that we would need to declassify, or excuse me, to reclassify as well. So it is based on the assumption that we would need to complete all the backbone infrastructure for the entire phase A, including the lands that we need to reclassify as urban.
That probably leads me to more questions, but I'll reserve them.
Okay, we'll continue with questions from Commissioner Higashi at 12:31.
When you leave the commission, you have to go.
We're gonna call all these witnesses. So,
No, I don't even have to.
Mr. Morris, are you available?
Yes, I am.
I enjoy waking up, dancing the ball with a gavel. This is fun. Things I have missed that I forgot. It is 12:35, sorry for the short delay. We are resuming cross-examination of Kamehameha School's witness, Michelle Schwartman, with continued questioning from Commissioner Lee Ohikashi. Please continue, Commissioner.
Thank you, and I lost all my stuff on my computer, but my question is this, is that within the solar project area before us today, has there been any infrastructure development there?
No, there has not been any type of infrastructure development within the solar boundaries at all.
Even for the solar items themselves, the solar panels themselves?
Yep, exactly. They don't rely on any wastewater. They bring in their own water. We've created roadways for access.
There is something, there's roadways for access within that.
They're dirt roads to access their site, correct?
And is there any infrastructure being planned for that area?
Like I mentioned in the earlier part of the presentation, there is no infrastructure being planned for future of the master plan, for the future master plan within the Clearway project development, because that there is no contemplation for urban uses at all. However, with regards to your question relevant to phase one, there is just our existing ag roads, which today they continue, as well as our own KS operations folks that keeps those open and maintained for fire or whatever we need to get access to our own lands.
Because my real question, I guess what I'm trying to get at is this, is that in the solar area that we're in front of today, that would be easier if I had it up on my own screen that I was referring to. But the ones that we're concerned with today, will any of the
Infrastructure
for that area for the solar panels be utilized in let me finish my question, in the development of the total area.
So I would say the only infrastructure that our phase one would remain in place for the future development of the WAIAWA master plan is the main arterial road. So we have worked with AES in identifying our future roads, and they are to retain that road through their project site.
And my question then would be to our Attorney General, whether or not by developing that infrastructure that constitute beginning of substantial lines.
Commencement. Is that a question you're directing to Mr. Morris, Commissioner?
Yes.
Well, it's not a question that can just be answered on a description like that, really. As you know, the courts have struggled with the idea of what substantial commencement is, and I can certainly provide the board, more detailed advice. It's not a black and white question. And so it's a nuanced question based on some of the criteria or discussions that we have in some published cases. Bridge Inalea, for example, it's a fairly low bar for substantial commencement, I will say that.
Commissioner Higashi.
I'm not clear what the answer would be, but I'm gonna mull over it.
Commissioner.
Well-
Oh, Mr. Morris.
And I apologize for referring to the board. I meant the commission, but again, it's a nuanced question, and I think I don't have enough information to answer the question completely now. I can certainly lay out the legal framework for you, or if you have requests to go into executive discussion, we can discuss it in that context. So on that limited basis of information, I can't answer that one way or the other.
Thank you, Mr. Morris. Commissioner Wong.
Chair, question. This is following up on Commissioner Higashi. Does he want us to go into executive session to talk about this at this time?
Sorry, the pronoun he referring to.
Commissioner Higashi.
I would eventually like to go to it, but I was just picking up some questions.
Okay. Did you have further questions for the witness at this time,
Not at this
Commissioner? Thank you. Commissioner Chang.
Thank you so much, Ms. Martin.
Commissioner Chang, could you speak directly to the microphone, please?
I really appreciated your very thoughtful presentation. It helped to clarify some issues, but it also raised some other additional issues for me. So, I am looking at the exhibit that you had, I think it was with the different phases. And it showed that 476 acres, Kamehameha Schools is going to pursue a reclassification. 71 acres is in phase 1, is that correct? Correct. Phase 8, I'm sorry, phase 8, you're right, phase 8, phase 8. I know, I too was getting confused, so phase 8. Is the 71 acres critical and necessary for the development of phase 8?
I would say yes. If you notice between, on that same exhibit, on page 4 or slide 4, you'll see the red bold line that demarcates the boundary of the urban district area. We have 2 separated urban district areas so connecting the boundary. So it's one cohesive urban district area would make a lot more sense in that we could have a lot more congruent development.
So your WAIAWA master plan that you presented, the 476 acres that has yet to be submitted to the LUC for a reclassification, those acres are critical for the implementation of the master plan that you presented.
That is correct.
And this master plan, the implementation of this master plan, specifically phase A, the infrastructure, is dependent upon the approval of the LUC DBA for the 476 acres.
I wouldn't say it's dependent on, the infrastructure is not dependent on the classification. They work in sync together, I would say, because what we build in infrastructure would accommodate whatever is approved within that phase A.
Okay, let me try to rephrase this. So according to your timeline, you are presenting, coming to the Land Use Commission for DBA for the 476 acres.
Right.
And that is the only, that would be the only jurisdiction, I should say jurisdiction, but And the EIS that you're preparing is for this master plan. Is that correct?
That is correct.
And this master plan is it dependent upon the 476 acres being reclassified? I guess that's my.
Yes, yes. As you know, the master plan that we propose is dependent on the 476 acres for reclassification. However, I'd like to add that, as I mentioned earlier, in our EIS process, we could possibly be looking at a smaller land plan or land concept plan where we wouldn't need as much reclassification. So instead of the 476, it might be less than that. We just don't know, as we still have yet to go through and analyzing what those alternatives look like.
So that might be an alternative. An alternative may be you go with the existing 1,300 plus acres that is currently zoned under where you would not require any additional LUC DBA. That could be an alternative, or the alternative to include that.
Possibly, however, in order to effectuate or implement our land plan, starting from the bottom, we would need to at least connect the two urban pieces. That number one looking, the finger looking urban lands with the larger group, the larger piece of land.
And that is in phase A.
Correct.
So, and I guess that's sort of kind of critical to my overall, one of my fundamental concerns. The LUC's condition to build the infrastructure by 2030 is, and that's an existing condition. But what I'm also hearing today is that the 71 acres for the DBA is also critical to phase A. So if you do not get a timely approval of at least the 71 acres for the DBA from the LUC, will you still be able to complete the infrastructure for phase A?
We would most certainly try. I mean, we would definitely, if this commission did not grant us approval of, reclassifying the lands into urban, we would then have to reassess and take a look at what can we do.
Because your master plan, there's a lot of assumptions in the plan that each phase is going to move in a chronological way, that you're going to get the DBA approved for the 476 acres, that the decommissioning will occur. So a lot of this is, it seems to be a great plan, but it also seems to be sort of conditioned upon certain things happening that you may or may not have any control over. You can kind of agree with that?
I would agree with you.
Because I guess we're looking at, this was originally approved in 1987. And I know you said Kamehameha School regained control of the WAIAWA land in 2012. And that appears to be the time where Kamehameha Schools put a lot of commitment and thought to this master plan. But prior to that, you were leaving it up to the previous developer.
Yes, that's correct.
So the first housing may or may not, well, the first housing based upon your plan is not anticipated to be built until after 2031.
Yes, shortly after we complete the 2030 infrastructure or meet that deadline, we anticipate starting vertical construction in 2031. And anticipate delivery of homes 2032, 34, in that area.
And your master plan, your EIS for your master plan, I mean, this is really a planned development over, is it the next 50 years? So will your EIS also contemplate, for example, your traffic study? Will your traffic study include the full build out Or are you looking at doing updates of those traffic study throughout the planning process?
So our EIS plans to assess the impacts over the entire build out of the master plan. So however, that said, you know, if there are updates to be made, amendments in the future, we would obviously have to do that as well. But what we contemplate today is to ensure that our EIS addresses the entire master plan over full build out and understand what those impacts are.
And I would assume from a planning perspective, I mean, that is a very difficult position to be in, because you are contemplating full build out on your project, but you are not necessarily, is your EIS also going to contemplate proposed build out all along the TODs, all the proposed development in that entire corridor or Ahupua'a of Kunia and beyond to Kapolei?
So I think, well, one, WAIAWA is an Ahupua'a of itself. And I believe, you know, as the Central Oahu Sustainable Communities Plan, which was revised and approved in March, I believe, of 2021, it identified the WAIAWA master plan of residential commercial uses and solar as an acceptable use and part of the long-term plan for that region. As far as taking into account other development from surrounding neighborhoods, I think there is, our consultants need to consider kind of the overall impact, taking the things that are in the pipeline, if you will. When we look at traffic, and obviously I'm not a traffic engineer, but you know, our consultants will have to take into consideration other developments that have approvals as well in their assessment of the impacts.
And I appreciate that. I think that, I mean, there's a whole question of whether the EIS will even be stale at the time that it's approved, given that you've got proposed development in phase E. So hopefully your consultants will take into consideration, and perhaps those could be future conditions of any kinds of approvals. Let me move on to ask you about community consultation, because I know that in previous presentations, there has been a lot of consultation. I mean, I think you know, there was talk with alumni, with the various stakeholder groups. Can I ask you, was the question or was the presentation to these various stakeholders, did it present the solar project as an interim project, and was the community asked whether they wanted to have housing done as soon as possible, or they were willing to wait for, you know, the solar projects to be decommissioned in phase?
So if I understand you correctly, that's a couple of questions.
Right.
Number one, to address the first, in our presentations to our stakeholders, did we share with them how solar is an interim use of our master plan? The answer is yes. We have been transparent with our community stakeholders from the very beginning. I think it is very aligned with all the things that Kamehameha Schools focuses on in the various initiatives. So the short answer is yes, we have included in our outreach the use of solar as an interim use.
And I'm sorry, go ahead, please finish.
And then can you repeat?
It kind of was an involving question, so I think the best way is let me ask you another question based upon your response. Based upon the presentations to the stakeholders and the transparency, was a question asked if the community had a choice of whether, in other words, Is it to permit the renewal hosting of the solar project as an interim use, or no, we'd rather have housing done quicker?
So I guess if I may, we've been transparent, and there was never any kind of feedback from the community that we presented to that we shouldn't do the solar because we want the housing first, because in reality, we have the housing going on as solar is already being built at the same time. So they're coming on board concurrently. So because phase A and B are moving forward, right? And then the answer is no, there has not been any feedback from any of the outreach that instead of solar, we want housing first, because they understood the long-term vision for Kamehameha schools was to have both.
Let me ask you this question. Is Kamehameha, the implementation of the master plan, specifically the housing, and even in phase A, is that dependent upon the approval of, is that dependent upon the revenue produced by the 2 solar projects?
No, not necessarily.
What do you mean by not necessarily?
So we are not dependent on the revenue from the 2 solar projects to, in effect, be able to financially build the master plan. The master plan will be in partnership with a number of partners. I mean, we consider the LUC as a partner. In order for the KS to complete this master plan, we need to work with the community. We need to work with the LUC and the various agencies that are sitting here. And we also need to work with a development partner and home builders. So we see this as an opportunity for a lot of partnerships to make this happen.
And I appreciate that. And I realize that there are numerous entities that will be working with you. But the estimated cost, I think you said, was about $665 million for infrastructure. And I also recognize that Kamehameha Schools has got, you're looking at perpetuity. And so you don't have a blank check. Somebody's got to pay for this. And I know you also mentioned that some of your considerations are economic. But I am wondering because while the Land Use Commission has approved the 2 solar projects, I think this kind of goes back to the question by Commissioner Ohigashi. Legally, if there hasn't been substantial commencement, could the property be reverted to prior to the zoning? I don't think anybody, well, I shouldn't speak on behalf of anyone else. I don't think it's my desire to revert, but I am looking at the realities of how critical is this solar project to the implementation of the master plan, specifically phase A, the housing and the backbone infrastructure.
So again, to restate, the solar projects don't dictate what the master plan does or the timing of our master plan. I mean, the delivery of homes is going to run concurrently with Clearway. So we have phase A coming up along with our Clearway development projects. And then of course, granted you folks reauthorize the use of those lands in phase 1 today, based on this motion in front of you, as they roll off, once they have decommissioned the future additional homes, by then we would have already about 5,000 to 5,000 homes in place. So just between phase A and B, we're looking at 4,000 to 5,000 homes. And that's a chunk of demand that we sure could use. So do I think that this commission has the right to revert the lands back to ag? I think you do. I think that's your kuleana. I just don't understand how that affects or how that helps our housing demand in Hawaii.
How do we understand what to do with that? I guess we just, there's just, we're also bound by legal precedent and how we have treated other landowners. And this was approved in 1987. So, but it is not, what you presented is an extremely appealing and necessary project for the future of Hawaii. So I'm not here to try to stand in that, but I'm also trying to balance those other issues that come before us. Let me ask you a question about the estimate. You have said the estimated cost for the infrastructure alone was about $665 million.
That's correct.
And I personally have, this has been sort of a mission for me on LUC. And you do not have to answer that question today, but at some point in time, if I still sit on the commission when this matter comes in, I will ask if Kamehameha Schools is willing to put up a bond that reflects that infrastructure costs. Because too often we have representations and they aren't necessarily full. Now, I know where Kamehameha School lives. I know where you live. So, I mean, we will go back and we will hunt you. So I know, I know you guys are good for it. I do, but I also, I have, that's been a point I've consistently made with other developers about a performance bond to ensure that those commitments are either met by the applicant or by somebody else. So again, you don't have to answer that now, but that is something I will ask in the future. That's my questions. I really greatly appreciated your presentation. It really helped me understand and clarify some of the questions we had from the last meeting. Thank you very much.
Thank you, Commissioner Chang. Commissioner Giovanni. No?
No questions, Chair.
Okay. Commissioner Okuda?
Thank you, Mr. Chair. I can't help myself, but a follow-up question to the lines of questions that Commissioner Chang and Commissioner Ohigashi raised. And, I do recognize, and I think we all recognize, that there's no issue or petition regarding reversion or anything of that sort pending in front of us right now, but that's like the proverbial elephant or rat in the room that seems to be scurrying around. So let me ask you this, okay? And this question, and let me preface it by saying this, okay? I don't want this question to be taken that I'm an automatic friend of the Bishop Estate or anything like that. I think the record would show that one of your trustees was a consultant in a case where I was the lone vote against what he was advocating. So, the fact, and I know one of the counsel in the audience can verify that fact. So, this question is not intended to reflect any type of bias or inclination one way or the other. It's just to clarify what the standard is. And so, we all know that the reversion standard comes from a number of cases. One of them is DW Ainalea Development versus Bridge Ainalea. And for people who are really interested in being bored at night, the Pacific Third citation is 339 Pacific Third, 685. The Hawaii
report citation I can give you, but my iPad is moving in and out. Oh, I'm sorry, I believe it's 134 Hawaii. And where I'm going to quote you is from 187, just so that we can see what the Hawaii Supreme Court was concerned about. And so after I read this section, I'm going to ask you whether or not, if you have just one or two sentence comment on whether or not that's really the situation that is being faced here with this specific request, this specific applicant, this specific landowner, and this specific situation. And I'll ask the same question of the community watchdogs, meaning the DPP and the Office of Planning. But this is what the Hawaii Supreme Court said, quoting the Senate Committee on Energy and Natural Resources about the danger of having land which is given entitlement and nobody does anything to go and make sure infrastructure or housing is really built. It says here, the Senate Committee, I quote, specifically noted that, quote, vacant land with the appropriate state and county land use designation is often subjected to undesirable private land speculation and uncertain development schedules. And that such speculation and untimely development inflates the value of land, increases development costs, and frustrates federal, state, county, and private coordination of planning efforts, adequate funding, public services, and facilities. Okay, that's the admonition or warning the Hawaii Supreme Court has given. So along that line, can I ask you this? Have you heard during your entire career at the Bishop Estate any discussion, no matter how small or minute that discussion might be, that the intention of the Bishop Estate is to flip or sell or for lack of a better term, speculate on the value of this land?
That's an easy answer for me. Absolutely not.
And you've already talked about the long-range planning that you folks intend to do, correct?
Yes.
As far as a master plan, I'm sorry for that question. Okay, so I won't go over that. Okay, I just wanted to make sure that there wasn't something which, we might have overlooked as far as some type of intention to, speculate on the land. Although I might say this, and this is a question I will ask also to the community guardians, the DPP and State Office of Planning. Does the Bishop Estate, because it serves disadvantaged communities, does it somehow, or do we take that into account when applying the standards that are laid out in the Bridge Ainalea case? But I'll leave that for them. Thank you very much, Mr. Chair. No further questions.
Thank you, Commissioner. Commissioners. Mr. Wong.
Thank you.
So easy to see you in person. It's just great. I'm not looking for waving hands over time on the screen.
But thank you, Chair. Several questions. First off, good afternoon. Okay, so going back to your exhibit number, what was it, 47 or 37? The one with 47, the one with the phases and A, B, C, D, and the solar.
The Gantt chart,
Yeah, no, not the Gantt chart, the one after
the
that.
PowerPoint.
The PowerPoint. So there's several questions I have.
Would you like to have it put on the screen?
Yes, please. Let's go to page 3 for now. Because I'll use that for a couple questions. So if you don't mind showing slide 3. That starts with a 2010 acres. Okay, so one of the first questions I have is, I know you talked about after after the EIS, you'll be coming back for a DBA, correct? For those things not in red, like first off phase A and also phase C, correct?
Correct. I think there's a slide that speaks directly to that.
Oh, no, yeah, well, it's more, it's gonna
Okay.
little more.
Okay.
So the question I have on this issue is two parts. Well, the first question I have is, we have two connections to H2 and I guess down on the bottom by the TOD area, correct?
Two connections, meaning access points
access
to
points
the
to the-
community? Yes, we actually have 3 access points for the entire project. And they're demarcated in the blue kind of stars or asterisks.
Okay. So you're not gonna hit the core ridge, you're going on the side of the core ridge. Is that-
That is the Kauka Boulevard. And that is planned for the latter phases of, actually, it's in the early phase of phase C.
No, the reason I have that is, I'm looking at this, just thinking loud, is for 2,000 something homes in phase A and 2,338 homes in phase B. Is that enough access points?
Yes, that is correct. We, yes. So we have engaged a number of consultants, traffic consultants, to help us analyze what are the capacities of those different access points. And in fact, as I mentioned here in one of my slides, in fact, the Department of Transportation has also concurred that, and with their support, they have concurred that connecting one of those access points to Waipahu Street and Kamehameha, they agree with it and they concur that as an access. So I guess the short answer is yes, those access points that we've identified would have enough capacity for those, for our project.
And I guess later on, for the OUC, you come with the TIAR with the.
That is correct, with the specific studies and outcomes.
So the next part I have is looking at this diagram again. As you said, in phase 2 solar farm, right, on the right-hand side, by phase B.
Yep.
So I'm gonna go a little bit into questioning on this. So we're looking at shutting down the solar farms eventually, right, for both sides, phase 1 and phase 2.
Correct.
I'm just thinking, and phase 2 will not even be touched because you're saying we're not gonna do any housing in there.
That is correct.
Don't you think we should look into the future, as you say, and say, we still need alternative energies, and there's gonna be more houses here? Have you ever thought about looking into the future for what's next to help, charge up or keep the electricity going for these houses, instead of looking at, or was that ever thought about?
So, if I understand correctly, the phase 2 project or solar development, which is being done by Clearway today, they have a decommission date of 2059. And I think your question is, what about extending that beyond? So they have a PPA that expires in, I believe it's 2049, and and this commission approved up to 2059 if they were able to get an extension from the PUC on their PPA. I think Clearway would be happy if we were to extend that area for continued use of solar. I do think though, however, today in 2022 and in 2059, the technology for solar, I think, would have made huge leaps and bounds. And if at some point later down the road, that land would be appropriate for continued use of solar, given the new technologies, that could be contemplated. But we really haven't thought of that, and that we really haven't thought of continued use. Who knows? I mean, we may have reached our goals by 2050 and the entire island is, or state is on renewable energy 100% by then.
Right, and we hope so.
Right.
I mean, I'm just thinking ahead, right now with this gas crisis and everything, that we do need alternative energy
Correct.
to reach that goals. So I just was thinking about that. The other thing I'm gonna ask then is, I know phase 2 solar and phase B of the housing, phase B housing, right, is, so phase A is gonna be housing first, then phase B is this next set of housing, phase C is the next set of housing.
Correct.
So is there a reason or rationale not to use phase C and instead of phase B, or that's?
Well, the reason why we identified those lands for AES, also known as WAIAWA Solar Phase 2 LLC, is because it's based upon the approvals of the boundaries that the commission approved in 2014. So instead of going before the commission and asking for a whole new area to approve, we thought that because the commission has already approved this area for solar use, it makes sense to already use those boundaries for solar.
No, yeah, so what I'm saying is, phase A, you still have to come back to the LUC for a DBA, correct?
For the entire project.
Right, so, and then phase 1 of AES's solar finishes in 2044, if I remember correctly. And the start of the homes for phase C starts in 2048.
Correct.
No, I just was thinking out loud, why you cannot switch the phase B and phase C homes? If you're gonna,
Because it actually, it aligns with our road network.
Okay.
And knowing the topography of that area makes all the difference as well. And so, it just makes more sense based on how our roadways occur and the phasing of our development, that they would use their phase A within that portion that we have identified here instead of switching them out.
That's all the question. I just wanted to clear that up in my mind. Thank you. Thank you, Chair.
Thank you, Commissioner Wong. Commissioners, further questions for the witness? Commissioner Giovanni, you good still? Okay. Chair has a few. Because you have the PowerPoint up, I guess I'm going to just jump into, there was one at least where I want to refer to the PowerPoint. So if you go to slide 9. Particularly the third row with content and then on water. Could you expand upon the update and outcome cells, please? The update is worked with Seaworm to test and monitor for existing potable water wells approved for the WAIAWA master plan. And the outcome was confirmed existing water use permits. Could you explain specifically what Kamehameha Schools has done in that regard?
Yes, so we have an existing, 4 existing potable well permits. And to stay compliant with those permits, we've been working with Seaworm, State Commission of Water Resource Management, on testing of those wells. And so we've been working quite closely with them and have capped them as well. So they confirmed that indeed we are in compliance with their standards for their of those 4 water use permits.
Okay, so for what use were those water use permits issued?
So if I understand correctly, the 4 wells were intended for the use of our WAIAWA water master plan.
So I believe, having commented on those permits, they were for golf course use.
I don't believe so, but I could be wrong.
Well, this is a factual matter that would be great to have. Your master plan did not get permitted or presented to us until 2020, correct?
There are a number of water, wells along within the WAIAWA area, but I believe those 4 wells.
To repeat my question, your master plan that you're referring to did not get in front of this commission until 2020,
Oh, that
correct?
is correct, yes.
Okay, when were your wells permitted?
They were permitted with the Gentry plan.
Okay, so it's actually for a different proposed use.
Yes, and as we retained the lands back and regained control of the lands, though everything, including those well permits, then came back to Kamehameha Schools.
Are you familiar with the provisions of the state water code that allow the water commission to revoke water use permits if the water is not used within 4 years?
I would have to confer with my counsel, but I believe you.
Okay, and are you familiar with the requirement that if you're proposing a change in use, you actually have to get a modification to your water use permit?
Yes.
Okay, so I'm confused by what the slide seems to be suggesting is that you're all good. You have 4 confirmed water use permits for the uses that you're preparing in front of us, but that's not actually the case, is it?
We actually have a number of other wells that we need to drill for. We have, at different water elevations, we have which will serve the various areas within that elevation. So right now we're working with the BWS on a 228 well to help with their own water master plan, which won't serve any of our water usage. And then we have another well site that we have yet to drill and get permitted. So I'm not implying that those are the only wells that we need for the entire master plan, but those are some of the wells that we need for the water master plan.
But my point is you don't actually have the permits in place that would allow you, unless modified, to use those for this master plan.
I would have to go back. I don't have the answer for that. I would have to go back and double check, but I had the understanding that those wells, if not all, were allowed for use of potable uses.
I can assure you the state water code, if you were proposing a change in use, and some of the proposed uses of those wells were for the proposed golf courses, that at least I would advise you that action from the commission is going to be necessary, so that I'm not actually convinced that you have necessarily any permits in place that will fully allow you to do what you're planning to do, or even partially allow you to do what you plan to do. Can you go to the slide with the vision on it? I think it's slide 2 or slide 3. That's the one. And really, if I had one set of questions for you, they're really around this. It's a beautifully stated vision, but I don't see the connection between the vision and what has been presented and reiterated as the master plan. So broadly, can you help me understand that?
Yes, so our vision for WAIAWA, obviously aside from the granular uses that we've been talking about today of housing and commercial uses and solar, this is really about how Kamehameha Schools looks at our lands from a much more holistic view. In WAIAWA, we have a total of almost 9,000 acres, among which a significant part of it falls within the preservation area and is a part of the very important watershed. So our land spans from Pu'uloa all the way up to the Oahu mountain range, and if you can imagine within this Ahupua'a of Waiawa, we have approximately, these lands that we have visions for use of inhabitants, and for life and for studying and for education and for cultural celebration and educational opportunities. Our vision, while it's difficult to see how it extrapolates into the master planning of things, it's where we start with. It's our approach of how we manage our lands and how smart we are with our lands. So we know there are opportunities within the WAIAWA Ahupua'a. And so our vision is based on using all those opportunities to deliver a community for residents and shoppers and people to recreate and folks to jump on the transit station and to have schools and other INA opportunities. And of course, what we're here today for is for the solar uses. So, I'm not sure if that helps. I guess it's hard to envision what we vision, but we do think that Waiawa is a huge opportunity to meet the demands of many needs of our community.
I guess I have a couple of responses and we can stop screen sharing. One is that the solar uses are not the only reason why you're here, at least according to the petition that you filed with us. You also asked for the waiver of a number of conditions. Is that correct?
That is correct.
Okay, so second is, I guess, it's a beautiful vision. It's a vision that I think is appropriate for Kamehameha schools. But what's in front of us is, well, it's certainly distinguishable from what Gentry proposed. I'm not seeing how it's particularly distinguishable from Coal Ridge across the gulch.
And we do have to do considerably a lot more studies. I don't have any of those glossy photos or renderings for you folks because we just haven't gotten there yet. We have a vision, we have some entitlements that we want to modify. We have an interim use for those lands. And really the trigger for us to start getting into the weeds of things and how we expect to deliver on our vision is getting to our EIS process.
So then I guess that's a great transition for my next question. Since you're a real estate professional, can you describe for me what you understand the difference between a master plan and an EIS?
Yes. So the EIS is an environmental impact statement, and it is part of the HRS 343 process. And that process evaluates the proposed uses and the impact of those proposed uses based on community feedback and public comments. And so there are a number of different milestones within the EIS process, from the scoping to the prep notice to the draft EIS to the final EIS. And so that's what that EIS is about. The actual master plan is a concept plan of proposed uses. It's not the study of the impacts of proposed uses. That's the defining difference, I think, between a master plan and an EIS.
How do they differ in terms of community engagement?
Well, the EIS is a requirement based on our discretionary permitting process. The master plan is just a plan, and a master plan is a just concept plan that hasn't been vetted through the requirements of an EIS.
So maybe this is where I either differ or just don't understand, but in my experience, the kind of engagement you can get with the community in an EIS process, because it's structured under 343 deadlines, tends not to be the deep level of engagement that you would try and get when you say, hey, here's our vision, for this entire Apupua, how are we going to see that play out on this?
So actually, before we even presented in 2020, we did exactly that with a master plan without the pretense of needing an EIS. We actually went to our own stakeholders and limited to, I guess it's not, you know, a much broader community. We did go and seek some comments and feedback of our overall vision of WAIAWA for Kamehameha schools. You know, that's part of our responsibility, is understanding, you know, we want to know that, you know, we understand what these lands mean to us and what are the opportunities that we can seize for the benefit of not just our own beneficiaries, but for the community at large. So I guess that's your question, is whether or not we've used exhaustive measures for outreach for just our vision versus being able to do that for our EIS. I think
Are you referring to the list of people consulted on exhibits 43?
some of those and then some.
Who are the things?
I think I mentioned earlier that Commissioner Don Hoshiro has mentioned or stated back to us. So we've met with a number of stakeholders, which include the Alumni Association representative group. We've met with cultural groups. We have, Kamehameha Schools has a number of stakeholders that we have identified as the, you know, young generation of leaders that we've presented to them as well. So, and then we've also presented to our Aina Ulu partners in Waiawa, down along the Pearl Harbor shoreline. So those are just some of the folks that outside of, you know, department agencies and state agencies that we've presented to.
That's helpful. Was there a reason that wasn't included as part of the outreach which you described in your written materials?
No specific reason why they weren't included in our written materials.
Did they tend to be supportive of?
Yes. I mean, and we've actually, I think I also mentioned this earlier in the presentation or in my testimony, that we also presented to you know, various University of Hawaii state chancellors as well. You know, we plan to partner with even the educational facilities or systems that are in the Ahupua, like Leeward Community College. And we have done that with Chancellor already. And in fact, we have other plans that we'd like to share with the various educational leaders from the university system as well.
But other than your whole testimony on that, that's just information for us, I guess.
Yes.
Okay. This is a small point, but I just wanted to clarify a statement, because I think if you read the record and just read your statement, it might appear unusual. You referenced the Gentry EIS. You said we're not relying on the Gentry EIS, we're doing the new EIS. Were you trying to suggest that the Gentry EIS is sufficient and you could have relied on it if you wanted to?
No.
Okay, then I guess, could you clarify why you referenced the Gentry EIS?
I think it was in the context of I think the entitlements. I can't recall why we were talking of what we were talking about at that time, but I believe we were talking about the various entitlements that are currently in place with the 1395 urban classified lands and zoning. I think it was in the context of that.
You made a couple references during your oral direct testimony and then in cross-examination to your duties to beneficiaries. But I believe, correct me if I'm wrong, what I only heard you refer to was financial commitments, the duty to derive revenue from your lands. Perhaps the strategic direction of Kamehameha Schools has changed since I worked there, but are there other returns that you seek from your lens?
Yes, absolutely. And my apologies if it implied in any way that that was the only obligations that we have for our beneficiaries. I mean, I stand corrected if you folks don't already understand that our mission is education for Kamehameha Schools. That is our primary business at Kamehameha Schools. However, we are very fortunate to have the ability to expand our reach within the extent of our community to provide other benefits to our beneficiaries and use our lands for agricultural purposes, for renewable energy, for housing, and even for commercial. I mean, I work for the commercial real estate division, and we are charged with understanding not just that we have a fiscal responsibility, but we have a responsibility for all the other things. It's not like in this case, it's not solar or the master plan. We have a financial responsibility, we have an educational responsibility, we have a cultural responsibility to our beneficiaries. It's not one or the other, it's how they coexist together so that we do the best job we can.
Thank you. That's very helpful. To get at how you managed to do these things simultaneously, you briefly referenced an absorption rate and an absorption study for housing. Could you expand on what that study was and how, if at all, it informed the phases of that you have in your current master plan?
Sure. So we did a market demand study in, I believe, 2018. And in 2021, we updated the residential demand study. And what that told us is that the demand for housing is even greater. The type of housing, in that study, we considered the impacts of the existing Koa Ridge and D.R. Horton's Ho'opili developments and how that impacts the demand. What we have learned and understand is that we cannot keep up with the pace. In fact, we need to try even harder to keep up with the pace, even though we may never meet the total demands of housing in Hawaii. At least we know that through WAIAWA, we certainly can take a chunk off of that. We can. So we've also learned that within the WAIAWA proposed master plan, there is a dire need for an intense increase in density. We've also learned that segmentation is important to what we deliver. And by segmentation, I mean that there are different types of houses or homes that are needed across our lands and in Hawaii in general. Everything from rental product to single family, multifamily. There are a number of different types of products that is in demand. And what our market demand studies told us is that we need to bring on a multitude of housing and different types of housing.
So I guess this is the part where I continue to be confused about the phases and the good questions from my fellow commissioner, Commissioner Chang, about whether or not there's competition between solar and the delivery of housing. Because certainly, like, one of the cudgels that is used to beat the LUC every year is the quoted, like, we need 10,000 homes, we need 50,000 homes a year. Nothing I'm hearing in your direct testimony suggests that there's a limit to the absorption rate that's very meaningful. You could produce all 11,000 of these homes in the next 3 years if you could, and they'd get absorbed into the market.
Actually, as far as absorption rate, what we've looked at is anywhere from 300 to 400 units a year. So
that's actually very different.
Then
if really all you're targeting in really delivering to the market is 300 to 400 units per year.
I think a large part of it has to do with the amount of regulation that developers and landowners have to go through. Do I think that what we've heard from DR Horton is that they can't build them fast enough in order to meet the demand? So because the entitlements are what they are, and there's no way for us to, obviously not shirk our responsibilities or permits or entitlements. There are a lot of buyers out there that are willing to buy homes, but we can't build them fast enough.
But this is what I'm getting at is, right, I mean, one of the number one reasons why people say that you can't build enough homes is there's not enough land in the urban district. This is all in the urban district. That barrier is overcome. But you're saying you still can't deliver more than 300 to 400 homes per year.
Well, what we've seen through our market study is that based on the trends today, that's what they're seeing is 300 to 400, because based on how fast they build it.
Sorry, I'm not following what you're trying to convey to me.
So I guess, so the absorption rate is anywhere from 300 to 400. And that's what we've been using as our absorption rate for our projected timeline in the master plan. What we're hearing in the market today is that other builders or other developers continue to build, but they have long lists of folks that are on a list to buy a home. So while we have, urban lands today, that doesn't mean we can build without any of our permits. I mean, we still have to go through our EIS process and our DBA and all the different entitlements and milestones that I outlined.
I understand that, but that Gantt chart could be considerably compressed, not over decades. If you wanted to deliver more than 300 to 400 homes per year.
If we could, we probably would. We'd want to.
If you could.
Correct.
So what's the constraint?
The constraint is that we're not using a plan that was represented by Gentry. We instead have a whole different plan, which triggers the need to come before you folks in the next 5-6 years, a couple more times for your approval. So if we can, work together to accelerate that approval process based on all these things that we've presented, that would be wonderful. And we would, like I mentioned, we need you folks as partners to make it happen. So I guess.
But what you're proposing for us right now conceptually is still not, it's still stretched out over decades. It's still stretched out over 300 to 400 units per year, not actually a level of production that would start to impact the market in a sort of tangible way.
That is absolutely correct. Right now, we have to still go through this process of the EIS to understand what the impacts are before we even land on a single master plan to implement.
Okay, couple more. And this goes back to my questions to you about the difference between a master plan and EIS. And you describe them as really two different kinds of documents. But the proposed stipulated agreement says that we could accept it either, we could take your EIS as in lieu of accepting a master plan.
I'm sorry, can you restate that?
So let me pull up petitioner's exhibit 40, or perhaps Ms. Thone can pull up exhibit 40. You entered into a proposed stipulation with the Office of Planning and Sustainable Development. Proposed condition 1, revised master plan, petitioner shall submit to the commissioner a revised master plan and schedule for development for the approximately 1,395 acre petition area by February 11th, 2025, provided however that this condition may be satisfied by the publication of a draft environmental impact statement. So this, when I read it, seems to say you're thinking of a master plan or an EIS as interchangeable, but your earlier testimony seemed to draw a distinction between the two.
Yeah, so I guess my reading on this is that if we're proposing to keep you folks apprised of our progress of our master plan. But however, if the EIS happens sooner than the 2025, then that would satisfy this condition.
I guess, and here's maybe where I'm moving towards opining, but I don't see them as the same. I agree with your earlier testimony. And this would also only work for me. You referenced in your earlier testimony that you're not sure about who the accepting authority would be.
Correct.
I don't see the meaning or power of this condition if there's another body who's the accepting authority on the EIS and it's simply handed over to us and said, here's what we came up with. I only think this works if the LUC is the accepting authority, but you haven't made that commitment yet?
Well, no, we have not identified who, I mean, right now, I think my best guess on who the accepting agency would be, it would be you. It would be the State Land Use Commission, as that's the next discretionary permitting process.
Yeah. I don't see this proposed condition working unless we're also the accepting authority. Because if we're supposed to have this as a meaningful condition to see that indeed the master plan has considered alternatives, the EIS impacts have been evaluated, and we're getting the housing that's been promised. If somebody else is accepting it, what are we supposed to do? Like, okay, they accepted it. Do you see any other meaningful alternative to make this operable?
I guess I can confer with my counsel, if you don't mind.
Please. Chair, short recess.
Yeah, I know.
Okay. Thank you for taking the time to consult with your counsel. Did you have a response to my question?
Yes. Just wanted to make it clear that with regards to the Exhibit 40 stipulated proposed conditions for approval, condition number 1, a little bit of context for that. The original 2014 condition 1 required us to come back within 5 years for with the revised master plan. Therefore, we came back to you folks in 2019, and that condition we wanted to remove because we satisfied it. However, I believe another OP wanted us to come back to the LUC with a revised master plan, but instead of just saying the revised master plan within another 5 years, we instead proposed to add language that we would come back to you folks with the draft EIS by that as well. So that's kind of, I guess, how that condition was formed. If, as far as the accepting agency or authority, I don't think after conferring with council that it is up to us as far as who is the accepting authority. I believe, if I understand correctly, that is something to be discussed and I guess agreed to between DPP and the State Land Use Commission. I don't believe we can make that call as petitioner.
I believe your earlier testimony was that you were working on determining the proper accepting authority. I might be misquoting you, however.
No,
Earlier.
that would be our next step once we've completed these proceedings for the WAIAWA Solar Site 1.
Okay. I believe my last question for you, at least for now, is that typically in our proceedings, one of our standard terms and conditions are that applicant is bound by the representations made before us. Are you able to bind Kamehameha Schools as to the representations you've made today?
Yes.
Okay, great. Commissioner Wong, followed by, I believe, possibly Commissioner Giovanni.
Chair, do you want to give Commissioner Giovanni, since he didn't ask any question? You just go real fast.
Commissioner Giovanni?
I didn't have any questions at this point. Thank you.
Yeah, thank you. Just a follow-up. Can you go to exhibit 46, please, the Gantt chart? And thank you again for giving us the Gantt chart. It helps me. Can we? I can increase this just a little bit. So on the top portion, you have the EIS process that will be done in 2022 to approximately 2025, depending on all these issues that may arise, right? So I'm not, but looking at the whole project itself from, and I'm following, this is Commissioner Chan, but she really helped me think about it. Looking at phase E, they'll be done in around approximately, or start approximately 2060, approximately. Do you, tell me when you're ready. You know, again, I'm worried about things can change, as you said, even with solar. So I'm wondering about the staleness of the EIS. If, you know, just because things change in our lifetime, you know, from rotary dial phones to push phones to iPhones, you know, that changes. Sorry, I should say even party lines for me. Sorry, I'm showing my age. Anyway, what I'm just saying is, EIS can get stale, things does change. You know, your whole master plan can change, you know, like that. So don't you think maybe you should look at maybe doing phase EIS with the phase development instead? Would that be a possibility?
So we have not contemplated it to date, but I guess we could take a look at that as a consideration.
Yeah, it's just that I'm worried just because of, you know, the Turtle Bay issue with EIS and others, that eventually things does change. And, you know, let's say we find out, hey, you need more roadways because Core Ridge is going to have all these projects, all these cars coming in from your TIAR, and you may need more roadways or something, and you have to do, you know, more TIAR or, you know, more infrastructure, or as Chair said, you may have to do more wells for water. Well, he didn't say that, but I was thinking about that. But, you know, those things may come up, and or more sewer lines, because. So I was just thinking that you may want to think about that you may have to do a phase EIS that's phased with, let's say, first one is phase A and B. Second one is, you know, C and D. And I forgot my letters after that, but that's what I'm just saying. But thank you.
Yeah, thank you.
Thank you, Chair.
Thank you, Commissioner Wong. Commissioners, Commissioner Chan. Ms. Dawn, if you would stop screen sharing, please.
Thank you. The chair raised some questions that I wanted to just follow up on. In all due respect to Commissioner Wong, I have great love for Commissioner Wong, but I do, hopefully you're not going to do a phase 3. Yes. Yeah, you will. I mean, I'm hoping what we will be able to do, and I'd like you to consider this, is within the conditions of any approval, should you come in for a DBA, that it contemplates that there will be updates. But I think there should be full disclosure, as you say, on your entire development. think the community needs to be able to comment on all of that. But I think we all appreciate the concern on a stale EIS. All right, let me just follow up. I think I read this morning's paper, had a chance to just take a look at it. Hawaii has the highest number of regulations. So I appreciated sort of the comment that you had, your comment to the chair's questions about the regulatory challenges. I'd like to ask you, based upon your own schedule, timing, by 2027, if all goes as Kamehameha Schools envisions and hopes, by 2027, all entitlements should be obtained. What would be the constraint at that point in time to expedite the development of housing rather than span it out over 40 years to build 11,000 homes, that you are accelerating the development of homes? Because I would suspect there is going to be a next generation of young beneficiaries who need homes. So what would be the constraint to keep this to 40 years for 11,000 homes?
And, you know, I think I don't want to speculate on, I don't know the answer to that question directly. But there are a number of things that could happen that could impact, you know, everything from a natural disaster could occur, or timely delivery of, you know, the rising cost of fuel and building materials to the extent where it's out of control, and it will have a severe negative impact on not just the home builders, but the homeowners and the purchasers or the buyers of those different communities. Those are just a few. We can have another economic downturn. We anticipate another economic cycle between now and then. However, based on the plans and the cost estimates that we've had, that's our timeline. That's our projected timeline. As far as speculating what could happen between now and then to deliver, who knew COVID would hit and impact us in a way that was so drastically changing? No one could have predicted COVID and its impact on us.
I totally appreciate that. I think many people have squandered 2 years during COVID to do much better planning. So I think that there are opportunities, notwithstanding extraordinary catastrophes. But I will share with you, my concern is, and I'm going to ask this to Office of Planning, how do we as the Land Use Commission evaluate competing state interests or competing state policies? We have an affordable housing crisis. We are short 40,000 homes. We have, you know, sustainable ag. We are shipping in 95% of our goods. We have a renewable energy goal. All of these interests on a limited amount of resources, and I think our time is accelerating given climate change. So it concerns me that this very ambitious project from 1987 to 2070, that is 83 years. 83 years from the time that the DBA was approved to the time that 11,000 homes were built. I understand that there were circumstances beyond Kamehameha School's control, but there were not all of those could have. I think there are some that could have been avoided. I think this was always your land. Gentry was, you know, they were the developer, but always Kamehameha School. So it does. I am very troubled by the length of time And I am 40-year stability, 11,000 homes, and you have all the entitlements that you need. And assuming that the backbone infrastructure should be built, seems to be an extraordinary amount of time. I would hope that at the time that this goes out for public review and stakeholder review, that you are considering accelerating that schedule. So that's probably more of a comment than a question, because I realize you kind of answered that. But that is going to be a real concern for me because of the length of time and the need that we have. My second question is, do you believe that Kamehameha Schools has a different kuleana responsibility from other developers?
Yes, I do.
Could you explain to me what that difference is?
You know, I don't believe that you know, the builders that we have today are a whole lot different in that they want to deliver communities to our island. There are a lot of good developers out there that have a lot of history in Hawaii and on Oahu, and they have done a great job so far in delivering awesome communities that you and I both, all of us, live in today. However, as a Hawaiian trust and Native Hawaiian education organization, I don't think we are any better per se, but I do think that we have a much bigger impact in terms of all of the different values that I mentioned before, as far as culture, education, energy, and agriculture. I mean, Kamehameha Schools is charged with a lot of responsibility, and I appreciate your statement about the LUC navigating through competing interests, state interests. We too, at Kamehameha Schools, go through that as well, and it's not an easy job, and we try the best that we can. And at this point in the life of the WAIAWA community, under the direction of Kamehameha Schools since 2020, that's what we're trying to do, is just do the best that we can and do what needs to be done to set up our development partners who are going to actually build the communities up for success.
I appreciate that. I think there's a heightened expectation, in particular by the Hawaiian community for Kamehameha. I think, and it is the competing interests that you talked about. When you were asked, what is your kuleana? I mean, it is education, it's culture, it's all of these things. And you have a trust that you need to ensure that continues in perpetuity. So I understand the very difficult challenges that you have. But I do believe that you have the opportunity, more than an opportunity, to be different from other developers. To be more than just putting up a sign with a Hawaiian name. So this is probably a harder question. How do you ensure that these homes that you are proposing to build will be built to meet the needs of your beneficiaries?
It's a great question. And my apologies.
This is hard.
This goes straight to my you know, one of the things that we strive for or aspire to, and one of our goals at Kamehameha Schools is to really Thank you. It's about having a Native Hawaiian identity. And in so many ways that plays out in our community, in our everyday life. From the moment we wake up to how we wake up our children in the morning, whether it's the way we say, you know, rise, Allah, Allah, rise today, because right now you have to get up and go to school, to how we address our kupuna in our different ways of respect. But, you know, in WAIAWA, there's an opportunity, as you mentioned, for the Native Hawaiian identity to flourish. And while I may not be doing the greatest job of translating how we envision that happening, I mean, there's the different ways of honoring a sense of place and doing the research and understanding the historical context that all the mo'olelo that Jason and his team understands, and preserving all the cultural places that are important. And, you know, kind of bringing that to life in a built urban development. And you'll see that it's places that we've done in Kamehameha schools, like Kaka'ako, you know, even when you get out of the car, you know what floor you are in Hawaiian. And that has some meaning to us, because everywhere you see in a community that has the Olelo Hawaii is a way or a small measure of perpetuating our culture. Even in the approach that we deliver our homes, or even in the way we negotiate contracts or easements, in every aspect that we do business at Kamehameha schools. I'm not even a graduate. But I feel the deep, deep kuleana in all that we do. And so, I'm sorry.
No, do not apologize. Don't apologize. I greatly appreciate that. I appreciate your passion and that it is a personal kuleana that you've accepted. So don't ever apologize. You know, I think Kamehameha Schools is in a very difficult position. You are viewed as the savior for all Hawaiians. They see you as a deep pocket, and you should be doing. But you also, you know, and I recognize that you have other responsibilities. You have economic consideration. You have to make sure that the trust continues. But I look around, and it is very it's painful, because our local kids, they cannot stay. They are living in multi-generations. And so I would, rightly or wrongly, I do have a higher expectation for Kamehameha Schools.
Fair.
I expect Kamehameha Schools to find a way to prioritize our beneficiaries, not only for education, but to sustain us as a people. And that means housing. And that means finding ways that you're not just building so that people from around the world can buy someplace in Kaka'ako. That's not kuleana. And WAIAWA, you have that opportunity. So I know you would take my heart first. But you look to Kamehameha to find a way. We have a housing need for our local, especially our local young people. And that this This master plan is going to be designed to be, when the chair asked you, what's different about this? And I know you said you're still in the planning stage. But I'd like to see from your community engagement that you are taking to heart those considerations that make us unique, and that you're incorporating that. And I didn't get a sense of that, but I know you're in the planning stage. That to me is community engagement when you're doing a master plan. What are you hearing? What are we listening? And how are you integrating that within your plan? But so I apologize. I am just, mine's is so much more, less of a question and more of an appeal to you. But you do have this is me personally. I feel that you have an obligation to be different. To do better. So, with that in consideration, accelerating these homes, 40 years to build 11,000 homes, finding a way to make this so that it is, so that our local people can stay here to live. And that you're finding a way to reconciling your own competing interests. As we try to navigate our own, it's on a larger scale. But I understand the challenges that you have. And I greatly appreciate how serious, and I know how genuinely you will take it. So I'm sorry for just going on and on and on. My apologies. Thank you very much.
Thank you very much, Commissioner. Commissioners, Commissioner Okuda.
Thank you, Mr. Chair. And I really do appreciate your testimony. If I can just slightly disagree with my dear friend Don Chang here. Okay.
Of course.
Yeah, Kamehameha Schools is a trust, which means the trust controls the duties of the trustees. And I think I know a little bit about Kamehameha Schools because I teach to graduate students. I'm teaching this year higher education law, and one of the cases that I sent to our doctoral and master's students was the John Doe case out of the Ninth Circuit Court. And as far as I can tell, there's nothing in the will of Princess Bernice Pawaki Bishop which charged the trustees with providing affordable housing to the community. Now that's a really good goal, and if the KSBE can work it into their plans, that's fine. But we should not forget the fact that it's a trust, and it's a charitable trust with specific duties and obligations with identified beneficiaries. And as much as maybe I might get criticized for saying this, yeah, when development stretches out over time, it cuts against what many of us have a goal as providing additional supply of housing, which hopefully might not drive down prices, but might moderate the increase in prices so that maybe our kids can stay in Hawaii and not have to feel like they moved to the mainland. But frankly speaking, if the trustees in their discretion, not being bribed or anything like that, in their discretion, come to the conclusion that stretching out the development timetable maximizes the assets to provide education to the designated beneficiaries of the Ali'i Trust, I don't see that contrary to the law. And in fact, if the trustees did anything other than that, they might themselves be breaching their fiduciary duties to the beneficiaries. Now, if for some reason the federal courts overturn the Ninth Circuit Court controlling case which upheld the admissions policy of the Kamehameha Schools, I might have a different view of that. And by the way, my statements aren't based on the fact that there's any racial or ethnic preference or anything like that. My statements aren't based on the fact that there might be a so-called constitutional suspect classification involved. It's based on the fact that the record shows that there's at least a recent history of KSBE looking out for disadvantaged individuals, disadvantaged families, and things like that. So again, I don't disagree with what my dear friend Don Chang had to say. But I would just like to point out that the primary fiduciary obligations of the trustees, as far as I can tell, does not include providing affordable housing to the community. That job rests with us at the Land Use Commission, with what's it, 301H housing projects, whatever else we can do. And if the trustees can help out, that's fine, but that's not their obligation. And I don't look to them as being, you know, taking that on where that's not stated as a part of the trust. Okay, thank you, Mr. Chair.
Thank you, Commissioner. Commissioners, questions for the witness? With the deepest of affection for my fellow commissioners, and these are important public policy considerations for Hawaii, but questions for the witness at this time? Redirect, Ms. Lim.
Thank you, Chair. Just a couple of quick questions, Michelle. I know it's been a long afternoon. So I just want to clear up a couple of things because I think I might have heard a few different answers. I understand that the master plan as currently envisioned contemplates a district boundary amendment for a portion of it, but it also contemplates a motion to amend. Is that correct?
That's correct.
And I also heard you say that through the EIS process, you may come to the conclusion that the most appropriate land plan to actually pursue to entitlements would not involve 400 some odd acres of reclassification.
That is correct.
It may include no acres for reclassification. It may include some number between 0 and 476.
Correct.
So, but no matter what, does Kamehameha Schools understand that it will need to come back to this commission with a motion to amend to request whatever the significant differences are between your ultimate plan and what was approved as the Gentry plan?
Yes, that is correct. Even if we decided not to go to the State Land Use Commission for a district boundary amendment, we would still have to go before the commission to motion to amend.
And is it your understanding that at the point in time when this commission is considering that motion to amend and they have all of the information from the EIS plus all of the witness testimony at that point, that the commission would have the ability to weigh in on timeframes for the development of that master plan?
I would imagine everything, they would have a chance to speak or make comments to.
Thanks, Michelle. And then my last question for you, and this is more, I don't want it to get lost. When we were talking about Exhibit 40, the stipulated proposed conditions of approval, and I take that back, I have two questions. First question is, with respect to condition 1 on the revised master plan, is it your position that no matter who the ultimate EIS accepting authority is, that pursuant to this condition, Kamehameha Schools representation and commitment is that a draft EIS or a revised master plan, but hopefully a draft EIS would be submitted no later than February 11, 2025.
Yes, that is correct.
So that doesn't matter who the accepting authority is, that's your representation. Thank you, Michelle. And this is truly my last question. With respect to condition 9 in that stipulated proposed conditions of approval, I just want to hear you affirm or deny that Kamehameha Schools has committed pursuant to this condition that the master plan phase A infrastructure would be in place by the end of 2030.
Yes, that is correct.
And so this would be, if the commission were to accept these conditions, this would now be a condition that would be imposed on this solar farm.
Correct.
Whereas the existing condition is really only imposed on the other solar
The
farm.
first one, yes.
Okay, thank you. I don't have any further questions.
Thank you, Ms. Lim. Thank you for your testimony. It is 2:29. I want to confirm with Commissioner Giovanni. Are you good till for the next half hour and then you're not available?
I'm good till top of the hour, then I have to go.
Okay. Yeah, 30 minutes. So With the forbearance of my fellow commissioners, we will plow through without a break. Ms. Lynn. Commissioner Ohigashi.
Thank you. Being old and infirm. I need help pressing the button. I was wondering, I'd like to see if we could go into executive session to discuss the issue that we raised about substantial commencement and the effect it has on our decision today. I believe that kind of discussion should take place in executive session. If there isn't time today, then I will probably move forward at the beginning of the next session.
Thank you, Commissioner. We could do it one of two ways. We could do that now, knowing that we would go till 3 and no longer. Or what I would suggest we might do, not knowing how long we might need for that discussion, we move it to the next time we take up this agenda item, which I believe is going to be Mr. Ordenker on May 25th. Which would also give our Deputy Attorney General additional time to prepare for that discussion. Is that acceptable, Commissioner?
Fine with me.
With that said, Ms. Lim, are you done? And we're moving on to DPP.
I'm done with witness examinations. Okay, I'll have some closing remarks that'll be very brief, but don't witness.
Okay, so let's use the next 29 minutes together to see how far we get through the Department of Planning and Permitting and the Office of Planning and Sustainable Development.
Well, Mr. Chair, one thing,
Commissioner Wong.
I know at the last meeting, we requested that if any witnesses can come, Mrs. Lynn's witnesses can come back if we have any questions after everyone does the presentation. Just want to reaffirm that.
The witnesses who are present today, Ms. Schwartman is here, Mr. Jeremiah has stayed, and Ms. Sato, as well as Mr. Nick Molinari. So all of the witnesses, are you referring to the ones who you heard as live witness testimony or the consultants who we've had sitting in the waiting room in Zoom?
That was, I guess, the one we had in Zoom, the last time we had a Zoom.
Ms. Sato, I believe.
Ms. Sato.
Ms. Sato is here in the room and she would be available for questions today.
I don't think it may be today, it may be after I hear from DPP and OPSD. If I haven't, yeah.
That, what I understood the commissioner to ask is, after we are done with hearing from DPP and OPSD, would the commissioners, would you make your witnesses available to the commissioners if we need them?
Of course.
Thank you. Is that it, Commissioner?
Yes, Chair.
Any further matters on our proceedings for the next half hour, commissioners? Seeing none. Planning and permitting for the City County of Honolulu.
Good afternoon. The Department of Planning and Permitting, DPP, would just like to clarify the letter that it sent in response to KS's 2021 motion. All right, so in its February 3rd letter to the State Land Use Commission, DPP objected to the proposed modification of condition 10 because it believed that the petitioner did not want to provide a supplemental environmental impact statement, the EIS. And so condition 10 in the STIP says that the petition area would be subject to Hawaii Revised Statutes, Chapter 343. And the DPP would also like the condition to state that it would be subject to HAR, which is Hawaii Administrative Rules, Chapter 11-200.1 as applicable, because especially in 200.1-30, it talks about the supplemental EIS. So we would just want to make sure that that's followed. And then also for condition 11, if landscaping is involved, condition 11 talks about wildlife protection. We would like, or DPP would like the petitioner to submit a landscape plan to DPP for review and approval.
The lengthy conditions, did you have a particular letter that you wanted that included in?
A, if landscaping is installed as part of the solar farm project, non-invasive plant species and native plant species. So if that happens, then DPP would like the plan submitted to them.
Okay. You have language at the ready.
We can provide that. That's it.
Okay,
Thank you.
commissioners. Questions for the Department of Planning and Permitting, Commissioner Chang.
Thank you. Ms. Weaver, I just have one question. Have you had an opportunity to review Kamehameha School's proposed master plan?
Yes,
Is it consistent with the county's general plan and community sustainable plan?
it is.
Thank you very much.
Further questions for Ms. Weaver? Commissioner Wong?
Thank you. You heard my question about the EIS. What is your opinion about, their phasing and the length of EIS? What does DPP's thoughts on that? Do you think the EIS will be stale, or will it be just enough for that whole 4 phases to 2060? What is DPP's idea or knowledge of that?
So HAR requires a new environmental impact statement if the effect of the project is substantial. So as long as petitioner complies with that. So at the moment, we haven't received anything, so we do not know.
Okay, yeah, I just was wondering about that, just because I understand HRS, HAR, but is there any city ordinances, ROH, dealing with that, or DPP's rules on that? Because of the Supreme Court decision on Turtle Bay?
For the record, this is Dina Wong with Department of Planning and Permitting. I'm the Chief Planner with the Planning Division. There is no.
You swear or affirm the testimony you're about to give us the truth?
Yes.
Thank you. Please continue, Dina.
Yes, I am not aware of any city ordinance or administrative rules, and we follow Chapter 343 and the related administrative rules on that.
So the second question I have, I guess because of Red Hill and water supply is under the purview of the city. What is the feeling with the city regarding this whole project and the water wells? Do you have any ideas or any knowledge of anything about that?
Well, this project is consistent with our Central Oahu Sustainable Communities Plan. The petition area is all within the community growth boundary, and as Michelle pointed out, the plan does recognize the WAIAWA master plan and the solar farms. With respect to the long-term water supply for the island, it's hard to answer that because there's so many unknowns on, what the Board of Water Supply can do in terms of increasing supply of water, what conservation measures can do. It's hard to answer. This area is not part of urban Honolulu where the shortage of water is, but it could be effective if water is diverted from other regions, but I can't answer that.
Okay, that's all. Thank you, Chair.
Thank you, Commissioner Wong. Commissioners. Commissioner Okuda.
Thank you, Mr. Chair. A question for DPP. Even though it's not the kuleana or the duty of the trustees of KSP to provide affordable housing or housing in general, does the DPP have any concern with the fact that if you look at the master plan and the schedule, a lot of this housing seems to be or going to be delayed to a point where many of us are not going to be alive when the last house is built? Is that a concern?
Well, I think we all like to see housing built sooner rather than later, but I understand that these are really long-term projects. And if you looked at Coal Ridge and Ho'opili and the length of time it took to get those started, it just seems to be the nature of these master plan developments. You know, the city has other efforts underway to get more housing built. We're focusing growth more in the primary urban center, secondary city in Kapolei. So it's not all putting everything in Waiawa or Ho'opili or Coal Ridge, but throughout the island.
Because housing is such a concern, are there things that the DPP could do within the bounds of the law? Not asking for special treatment or anything like that, but are there things the DPP could do within the existing framework to assist developers such as KSBE to move forward with their development? In other words, to cut the red tape, if there is red tape, or to find out where the tape is if nobody can figure out where the tape is.
One thing that the department could do, and we are looking at, is expediting building permit processing. But that will be further down the line when they come in for actual permits.
Okay, last question. The state at great expense once sent me, periodically sends me out to learn new things, and I actually try to pay attention. There was this one city on the San Francisco Bay that actually designated somebody to be like a concierge to cut through the red tape. Just so that we don't have an amorphous question here, would the DPP commit itself today to have somebody work with KSBE to expedite, where possible, this development? In other words, so there's a commitment on the record here that the DPP will have a designated person to work with KSBE and its planners, who I think we can make a finding seem to have the community interest at heart, to try to move this development forward in an expeditious manner. Can we get that commitment from the DPP?
I think we can give a commitment that, you know, everybody at the department, and if it comes, it will touch many divisions within the department. When they come in for the zone change, it will be in the planning division. When it comes in for the building permit, it will go through building permit, building division.
Yeah, I don't mean to interrupt because time's getting short, but so let me just ask the more pointed question. Would it be okay if you state on the record that you would be the person that if, I'm curious about this, that you would be the person that KSBE can call if there seems to be a problem, just so that we don't have unnecessary bureaucracy get in the way of a project. This is not to say you have to prove it, but at least there's a live body with a telephone number and an address where, you know, contact can be made. Would that be okay?
There will always be a person that they can contact, a live body, but I wouldn't be able to commit to say who that would be.
You wouldn't be able to commit. Okay, well, let me just urge that, you know, that when everybody's responsible, like I tell our staff at our office, nobody's responsible. So you can just consider that to try to move things forward. Thank you very much, Mr. Chair.
Thank you very much for that valiant yet unsuccessful attempt. Further questions for DPP? So I just want to know, are you taking a position or not taking a position as to the length of time over which the housing production is stretched out as proposed in their master plan?
No, we don't take a position on that.
But the city does sort of generally take a position that you want more housing production,
Yes.
but just not necessarily here on this project.
I think once it's sort of out of our control. I mean, we do the processing of the permits and the approvals, but whether it comes down to their financing or conditions that we don't have any control over. It might just be the nature of these long-term, larger master plan developments.
I will forego the dissection of why certain other master plan developments took longer, but thank you for your comment. Anything further? Commissioners? OPSD, you have 15 minutes. How far do you want to go? And I want to actually reserve a couple of minutes at the end for procedural matters.
We have an argument to make, and we could make a valiant attempt to finish that in time.
Okay.
The Office of Planning has no objections to this motion to amend in order to allow a solar farm to be developed. The impact reviews we think were well done. The requested accommodations for more time is reasonable for a solar project that has already been approved by this commission under somewhat different circumstances. And we also think the impacts from the solar farm were adequately addressed. So in the particular motion before you, the Office of Planning has no objection that that motion be granted. I want to address probably the larger question of what's going to happen with the housing development. Before I go there, though, I do want to address some particular questions that I think the commissioners had asked or indicated they were going to ask me. So let me just assume you're going to ask me this and try to ask it now. The first was, how do we evaluate conflicting or competing state interests? And this is a particularly difficult question because there are really two different issues that are going on. Because no one single piece of property can satisfy all of the different conflicting needs of the state to both sustain and develop. The problem is you need to look at a particular piece of property in a larger context. But you're doing so in a contested case hearing that looks at the facts of one particular piece of property. There is a much, much longer discussion on this, but let me give you the 30-second reply, which is the city and county of Honolulu has done a larger review of the various uses of all of its lands in the county. And they have determined the various uses that would best be able to meet those balancing and that would best balance those conflicting purposes. What areas should be reserved for agriculture? How do you keep the country country? What areas should be preserved and what areas should be developed? Because development is important. You can't keep the country country if you don't have a strong urban core. You need a place for that demand to go. And that is done at the county level through their sustainable communities plan. And this particular project, including the solar, is part of the community, part of the sustainable community development plan for this area. That still means you need to look at the particular facts of any particular request and the timing, because the sustainable community plan does not mean every single piece of property that's designated for urban use should be developed all at once. So you do still need to do a case-by-case analysis of the particular request before you as to whether that particular urban use in that particular way would be appropriate and should be granted. So there's a much longer discussion, but that's sort of my best 30-second reply. You also asked, how do we evaluate motions? Do we evaluate matters differently if the petitioner is a charitable organization or does good for the world? In its basic element, the answer is no. Every petition is evaluated on its merits, not on who brings it, with some exceptions with respect to if you have to evaluate the petitioner themselves, for example, financial capacity. You do, however, evaluate different uses. So one use is for luxury condos, and another use is for single and multifamily housing. You might look at those uses, or you would look at those uses differently because they fulfill different uses in the community. You also asked about, I think what you referred to as a phasing, EIS phasing. And I think maybe I would reframe that to ask, how do you account for the need for a supplemental EIS as time moves on? And that's an interesting question in this particular project because of the length. And I think it does need to get addressed. The Office of Planning, I think, believes that this needs to be addressed in the motion to amend the conditions and the potential district boundary amendment that will come before you. That and many, frankly, other questions. When you ask about, do you have concerns about the length of time, this plays into the exact same question, which is, we do have, it does make things very complicated. When you come to the Land Use Commission on a particular case-by-case analysis for something that's going to take so long to develop, because our ability to predict the needs of the state and the ability to predict what the conditions will be over that length of time is very, very difficult, which doesn't mean we will say no, but it means the analysis does become more difficult to do and frankly, a little more tricky. It may need to account for the need for updated studies. It may be we approve it as a not phased, interim, incremental districting. And I'm not saying we will, I'm not saying this is what we should do here. What I am saying is these are some of the difficult questions we're going to have to face when this comes back, come back to the commission. I've actually made a list of several other issues that will have to be addressed. So I'm just going to take the opportunity to let everyone know, Kamehameha, that these things are going to have to be addressed when you come back, including the water permits, the adequate traffic analysis, issues involving substantial commencement, issues involving compliance with your representations, future solar uses, the absorption rate of housing, and frankly, many other things. So these are important questions. They're vital to the larger project, but from the Office of Planning, we believe these are issues that should be addressed, not today, which we think should be approved because it's just for the solar part, but in that larger question. Let me, as quickly as I can, because I know I'm running out of time, try to then address the questions that have been raised regarding the dilemma that occurs involving housing and what is the extent of the Land Use Commission's power to require development. This came up, as you may recall, many months ago involving an affordable housing project. And how do you force a developer to develop rather than allow the developer to revert back? And it's tricky. It's hard. There are limits to the Land Use Commission's power. There just are. And if a private landowner doesn't want to spend the money to develop a project, what other choice do you have other than revert the property back to agriculture? I want to let you, and so when we look at this particular case, what we have to remember is this was approved in 1988. If you look back at that decision, there was no condition for compliance with their representations, none whatsoever. There was no condition for substantial commencement of backbone infrastructure or substantial commencement of the project within any period of time, none. That's simply what the LUC decided in 1988. Subsequent to that, they came back in 2014. Actually, let me take a moment and what's important about that is, if you look, because this will come up in your discussions with your attorney, is if you look at HRS section 205-4, what it refers to is it says the Land Use Commission may, by condition, require substantial commencement of the property. And if they do not, then you may revert. And the question is, what happens if you don't have a condition? Whether they substantially commence or not. So whether or not this does or doesn't constitute substantial commencement, more important question might be, what can you do even if they do substantially commence when there is no condition to do so? Subsequent to that, although this will, as I indicated, will be an issue we will need to address when they come back. The subsequent issues have come in 2014. They came for an amended DNO, and there was a fight back then. I'm not sure if everyone remembers here, but there was a fight over the requirements to submit a revised master plan and a development for that. It was something OP held very firm about, without it, OP was not going to support a solar permit, which in and of itself was something that was good to do. We did require that they substantially comply with the representations in the development and operation of the solar farm, because at the time that's all we could get. You remember, because it's only with relation to the solar farm, but we thought for that at least we could link it there. As you may recall, conditions have to be both roughly proportional to the impact as well as connected to the impacts of a project in order to be constitutional, not constitute a taking. So we got that from that. Subsequently, in 2000, they did submit a revised master plan, but it's just the submittal of a revised master plan. It's not a house. It's just a piece of paper, an important piece of paper, and a piece of paper that involves consultation with many people. That's an important thing to do, but it's still a piece of paper, not a house. And then in 2020, they came in again because stuff again happened. And at that point, what was one of the important parts of that, and there was a big fight, you may remember, or a big discussion about the backbone infrastructure requirement. And you specifically required them, and they agreed, at least they didn't appeal, the requirement to complete construction of the backbone infrastructure for phase A by 12/31/30. And that was important because we knew that they were going to have to come back to the Land Use Commission at some point, because based upon the uses in 1988, we knew it was not going to be the same as it was going to be in certainly 2030. So much of what we have looked at in this, in particular motion, has been what can we do to require them to come back to the Land Use Commission as soon as possible? Because that's what's going to have to happen in order for those houses to be built. So we knew they have a sort of a general idea. They were looking at develop a district boundary amendment for a certain piece of property on the southern or the Mackay section, because that was important to, let me try to finish this and then summarize. That was important because that was their connection to other infrastructure and other houses. So we thought they're going to have to come back to you for something. And the question was, how do we force them to come back? And so condition 1 was part of that. That is the environmental impact statement. It was not put in there as a replacement because we thought that was a way to connect with the public. It was a way to make sure they came back to the Land Use Commission, because in order to do a draft EIS, you have to hire consultants and you have to pay a lot of money, which you will never get any money back from until you proceed with the development and the sale. So the reason we wanted, and because in order to do an EIS, you have to know what you're planning. So it might not have maybe the same consultation process with the public, but it gets them back to the LUC. It puts a deadline by which it will encourage them to come back to the LUC, because the EIS was such an important and expensive element, which would have to be completed for that process. So it put a time deadline on that important provision. I know I'm running out of time, so let me just conclude by saying this particular matter before you, we think, is not a difficult question because it's involving solar. The second issue before you is going to be much more complicated. And all we're asking is you not conflate those two things. Approve this, and then let's move on to the next step as soon as possible. Thank you.
Thank you, Mr. Yee. We will reserve our opportunity to ask you questions at our next meeting on this matter. Is 2:58 p.m. I thank everybody for your forbearance as we went through our first hybrid meeting. Ms. Lim.
Chair, Commissioners, in light of the request to your AG to provide some kind of analysis on substantial commencement, petitioner Kamehameha Schools would ask for the opportunity to provide a simple brief to be filed to provide our analysis of the substantial commencement issue, if in fact that's still an issue.
We certainly wouldn't object to any briefs that you want to file with us on that matter.
Thank you very much.
Same goes for DPP and OP if you chose to. Thanks for everybody's forbearance in the virtual and physical worlds with this. What I wanted to make sure to make space for is that Including a very long and successful career as the administrator of the State Land Use Division with the Office of Planning and Sustainable Development, Rodney Funakoshi is no longer going to grace us with his presence. This is his last meeting before his incredibly well-deserved retirement. And I will say, as somebody who, it'd be no secret, while I have not always agreed with Mr. Funakoshi on every stance he's taken before the commission, I have no question about his commitment to do what he believes is right for the state. And I hope everybody would join me in thanking Rodney for his service to us and wish him the best. This is for you, and do you want to say something?
Appreciate the sentiment.
Okay, thank you very much. With that, I believe there's no further business to attend to. And our meeting is adjourned. Mahalo.